ahead and I'm going to call this meeting to order. Welcome to the Wednesday, January 12th meeting of the Broker Responsibility Working Group, Texas Real Estate Commission. For the record, my name is Chance Brown and I am the chair of this group. I am going to turn things over to Mrs. Burgess to give us some housekeeping since we are online and not in person like we had hoped we would be, but thus is the fate of Omicron. So.
Okay. Good morning, everyone. It's good to see everybody. I'm going to do my standard housekeeping, which you all have heard 1,000 times, but I think is always a helpful reminder. So if you are part of the group, it's helpful to have your camera on to the extent that you can. And you can, for anyone who can't see everyone, because I always forget that you can do this, you can put it in large gallery mode and then be able to see everyone who's got their camera on. For me, it's like you can go up to that dot at the top and click on it, right? Am I making that up? Yep, that's right. And you'll see like a large gallery and you can do that. You can also do together mode if you want to be entertained. We do ask that everybody stay muted unless you are speaking. And for those of you on the committee, always feel free to come forward and speak up when you want to. There is the raise hand function, which is up in the left. It looks like a smiley face with a hand next to it. And we ask that the chat only be used for any kind of technical issues that anyone is having. Just that way we have everything out there and everyone is hearing the dialogue and we've got it recorded, etc. because we do post this. And I think it sounds like I got a message that Soccer is trying to log on right now. So she should be here in just a minute. But that is it and there's Bill. That's it for the housekeeping.
Oh, perfect. So we have everybody. Hey, Bill. Good morning.
Good morning. Happy New Year.
So let's jump right in because we have a very busy agenda day and we have a lot of things to discuss. So agenda item number 3 is public comment, including any written public comment received on non-agenda items. We have a very well thought out presentation about the unintended practice of law from Mickey Lackey, or unauthorized practice of law, sorry, that she presented. I'm assuming everybody had a chance to look this over. And so I want to have a chat about it and see if there's anything that we want to do on this. I will tell you a couple of things before we get into any discussion about this comment. Number 1 is, I know that this is up for discussion under the rule review that the commission is doing as a whole. And so I know that they're going to be talking about this. I don't necessarily know that it makes a whole lot of sense for us to get too involved unless they ask us to after their rule review. But the other thing that I asked Mr. Malloy to look into is how often this is a problem. And the answer is 6 times in the last 5 years. So not a very large one.
Sorry, that's for the technical violation. There's been a few occasions where it's kind of been on the edge or the person, we negotiated maybe a different violation than, 1101.654, but it is, I can confidently say in the past 5 years, someone that we disciplined under this has been at the most a dozen times, a license holder. So it's very rare. It may be alleged, but in general, it's not an issue that we face on a regular basis. So
I don't know if we're making a problem out of one that doesn't. I don't want to dis her point altogether because I think that it's valid. I also don't know if it's something that should be broker, lawyer, and or ESAC when it comes to how we put this out to the world. So I'd open it up for any comment on this. from everybody else. Yes, sir, Mr. Baker.
I'm glad to hear we haven't had a lot of things that rise to the level of a track complaint. And I'm glad to know the commission is looking at rules, possible rules change. I encounter this issue almost daily with my agents. And frankly, one of the first things that's been a battle for me is to make sure my agents understand that it doesn't matter if the other side is putting it in the offer. If they allow their client to accept it, they're responsible. And we're seeing language going in. I'm looking at one right now in which, you know, the party on the other side did something and it just, I mean, so I think we've done a great job as brokers trying to keep this, people understand it, not let it get to a track complaint level. But it's an issue that I'm really glad they're addressing, because I probably get several calls a week dealing with this issue among my agents. So I don't think we need to spend a lot of time on it, so otherwise it's being done, but I'm glad we're not letting it get to the complaint level, but it certainly is an issue that we're dealing with, at least in my area.
So, Mr. Baker, can I ask a question of you?
Yes, sir.
When you get those questions, what's your response to your agent?
Well, it's always somebody's got to talk to an attorney. You know, we've always got to take this off to an attorney. If there's any questionable language, anything going on, we have to, in writing, such as an email, advise our client. And that's all we can do as we work through the process. We've got to follow instructions of our client, but we can interpret it. It's that interesting thing that TREC has, that on the one hand, we've got to tell our client this is something that could affect the legal rights of the parties, but we can't tell them how they could affect it. That's a fine line. We're going through a process right now. I've had two of them in the last 2 weeks dealing with Zillow properties, and they've got a contract they're using now. Right. And I've had to make sure our clients understand, our agents understand, you cannot advise your clients on a non-promulgated form. You've got to have them seek legal advice and go through that process. And this is going to be something that's going to pop up more and more. We've always dealt with it in the builder contracts, but now we're dealing with it with certain institutional deals in Zillow. And if the unauthorized practice of law comes in when they start looking at something like that, one, it's okay if I understand the TREC rule. It's okay to say, here's some points in this that you need to be aware of that could affect you. We can't tell you how. You've got to seek some legal advice. And we've got to do it in such a way that they don't feel like we've abandoned them, that they feel like we're trying to help them out and work through the process. So yeah, we really, I mean, it's, my agents are getting tired of me hearing me say, well, what do you mean, Bob? We got to have them send them to an attorney? Well, yeah, you do, because we don't have the authority to deal with that, and they need to understand our limitations. So that's what I do.
Very good. Thank you, sir.
Yes, thank you.
Buckles.
Good morning. I wanted to raise one thing. I'm sorry I'm not at my office and a little bit more present in this meeting. I'm coming at you from quarantine thanks to Omicron. But I did want to just mention that one of our commissioners has, well, the commission received these comments, and one of our commissioners kind of circled back and said, this is a real problem. I look forward to seeing, what's done about this. And so I wanted to just say that, so that y'all knew that this is something that the commission is paying attention to. And my anecdotal commentary is that there's often confusion about what requires an attorney, what is the unauthorized practice of law and what isn't. It may be that clarification is needed, or even just some education on that in the form of an article or something that TREC can do. But I wanted, on behalf of that commissioner, to just say that this is something that they're paying attention to. I'll lower my hand now.
Soccer.
Hello, everyone. I got my technical difficulties solved. I have a question. Haven't we had articles on this before? Hasn't Trek? Yeah, we've had articles when we as instructors teach the inevitably we teach the contracts class, and then I always ask the question, has anyone seen this language, or what are you doing with people who are asking you to do this? And I've had agents say this to me. My broker went to an attorney and the attorney gave us language, and that's the language that we put in special provisions. I don't know. What about that?
I mean,
We've definitely had articles written on it, and there's been a lot of education on it. It seems to come up enough to where we can't ever do enough. And so I
Right.
think that is the reason for the question is, should we be doing more? What does that look like? We welcome your feedback.
I think
Yeah,
we need to
I mean,
talk
I'm not
about
an
it
attorney,
within the
soccer.
broker responsibility class all the time.
Yeah, I'm not an attorney, soccer, but to me, an attorney writing something that's just a blanket thing that goes in special provisions, and that attorney isn't representing the principal to the contract is scary. So, Mr. Baker. You're still muted, Mr. Baker.
I'm sorry, I forgot to lower my hand.
Oh, okay.
Thank you.
Yes, sir. So does anybody have a suggestion on what we should do here, if anything? Like I said, I don't want to dismiss it outright. I know that it's being reviewed at the commission level as part of their rule review, and maybe that's just where it needs to stay, or it needs to be with broker lawyer on how they more clearly define that. But I don't want to, obviously I don't want to outright just dismiss a public comment. Yasmin, did you have your hand up? Then it went down. Okay, Mr. Sales? You're muted, Brian.
There it is. Okay.
There you
Good
go.
morning, all. I think it's an issue that we can address, but I don't know that we have enough information or direction at this point. So perhaps we calendar it for a later meeting and put it on the agenda as a topic of discussion.
Okay, Mr. Baker?
I think I agree, and I think that our reply, and I think it is reasonable to have a reply so that the person, the author, knows that we've seen it and addressed it, is to let them know that the commission is working on this and that we're working in concert with the commission for a future agenda item, as Brian mentioned, to be respectful of the, this is a very well-written thing, a lot of good information in there, and frankly, some information that I hadn't thought of. And it's very good, and I want to respect the author for doing this. And so we can reply and let her know that this is something that is going to be addressed in the future, and we certainly are receptive to having it on a more serious agenda item when we have more information, as Brian points out. So I think we do reply, and we let her know that, yeah, here's what's going on.
Thank you, sir.
Mm-hmm.
Ms. Perez?
Mr. Baker just pretty much said what I wanted to say, but yes, I agree that it is an issue that needs to be addressed. And like you said, Chance, I don't know that we have the capability to address it fully ourselves. Maybe it needs to go more to other departments, but yes, I agree. I think we need to spend a little more time on it and see who's the right department that can help us or just address it better than we could.
Okay. Soccer?
I just thought of something from the education standpoint. Legal update 1 and 2 and broker responsibility. I think a section that needs to be added to both of them is examples of an unauthorized practice of law, and just give examples in every single one. So when people take Legal 1 and Legal 2 or broker responsibility there, it's always in their face. This is the unauthorized practice of law. If your client wants to use an escalation clause, every single client has to consult an attorney on their own and not a blanket statement from an attorney for the company.
Ms. Bird.
I was just going to say, in particular, in response to what you just said, Soccer, I'm taking notes on this. We look at those courses and we can make a note that there's been a recommendation from this group on this. As noted, we're looking at this rule as part of rule review. There is a bit of a conversation on what does this all mean? What can TREC put out that is helpful but not limiting? I never want to be in a position where they're like, well, you didn't mention that, so that can't be the unauthorized practice of law. And that goes bigger than these comments, but just in terms of how we can holistically address this, not only through rule review, but through messaging, through conversations at the commission level, which I think will inevitably happen with our rule review. So that's very helpful. And Soccer, I will make a note for legal update and broker responsibility, and Jennifer's here. So
thank you.
Mr. Malloy, can I pull you back into this discussion for just a second, please, sir?
Yes, sir.
When we see things that are related to unintended or unauthorized practice of law, is there a common thread?
No, I mean, it's a bunch of different examples. I mean,
okay.
It can go from, a real straightforward one, like several years ago, someone decided as an agent to draft a warranty deed. That's like clear cut in my book. Well, other ones where, the practice of real estate is really it's on the edge of, being the practice of law. It's the clients always want to help, they want to have their best interest for their client. I get that. There's that balance, and a lot of people have a hard time understanding that, because if we regularly get questions asked like, my client wants to know if we can void this, if this contract's voidable, or something like that, or how this impacts my client and stuff. And we can't provide that because we don't know the full information of it, and we're not their clients. They're trying to do the best thing. But it's like kind of a slippery slope where I think we've attempted to put a dam, sort of, where providing examples, but you can't provide an exhaustive list.
Gotcha. Okay, because there's not a common thread. That was my thought, was we're going to do what Soccer was talking about and put something into an education piece. If there was a common thread of, let's make sure we talk about this, but if there's not, because each one is a different fact-based scenario, then I think it just needs to be more of a general approach. I tend to follow the Lori Levy advice that good facts make for good defense, and so if it's not in writing, it doesn't really matter. And so that's when we talk to our agents. If something comes up like that and they're being directed by a client to do something, that direction has to be in writing, and it has to be exactly what's written, not we're going to copy and paste it into special provisions. We're not going to come up with something on our own based on an email. So, all right, thank you, sir. Okay, so if everybody's good with it, I think if somebody takes the time to put 18 pages together, and it's, clearly a very well thought out argument, like Mr. Baker said, I think it definitely deserves the respective response. And so I will work with Vanessa. We'll make sure we respond, and we'll go from there. And if we get some more direction after rule review, we can take a look at this again, if that's okay with everybody. All right, Vanessa, we didn't have any other public comment beside that, right? Very good. Moving on. Agenda item number 4, the discussion and possible recommendation regarding 535.56, education experience requirements for a broker license and forms adopted by reference, Supplement A and Supplement B. So we did get some comments. I presented this to the commission at their last meeting, and there were some concerns from the commission, which we can talk a little bit about. And they agreed after some discussion to go ahead and put it out for public comment. I expected a whole lot of public comment. We didn't really get nearly what I expected we would, which I don't know if it's good or bad. A lot of it I noticed was people who clearly aren't strong on reading the actual supplement and doing the math. But there was a lot of positive stuff here, which I felt really good about. So you can see this one is the previous broker response committee is still under review, single broker license, sponsoring broker license. I mean, if Chelsea or Vanessa want to talk about this, I don't think there's any discussion of that happening, is there? Breaking the broker's license in two?
No.
Okay, so there you go. We didn't reduce requirements of transactions completed to get a broker license. They read the first part. They didn't put the points on the math together in this one. So, Mr. Baker, you had a comment? You're muted, sir.
Yes, I'm sorry. This might relate to what we just said about not breaking the broker's license into two licenses. One of the comments in there, and something we did talk about in previous meeting, was the difference between someone who has a broker's license and someone who's a sponsoring broker. I really think we've got to address that at some point. I think there's in the previous group meetings, we were very clear that if you're going to sponsor other agents under your broker's license, you're at a different level of responsibility than if you're just responsible for yourself. Now, you still are responsible for the public and clients and all that. We understand that. But if you have a broker's license, you got a broker's license, and then you decide overnight, well, hey, I think I'll open up an office and have 100 agents or 10 agents or something. I think we somehow have to address that. There's got to be some requirement for somebody to be able to do that. And I think this is the group that at some point in time either need to say, no, Bob, that's crazy. We're doing fine like we are, or we need to address it. Because I think it's, when we look at all those comments that we have that we're going to talk about soon, I guess, and that we got about the incompetency in new agents and all that, so much of that comes down to the brokers and their responsibility and their ability to train their agents and be responsible for their agents. And I think in some way, shape, or form, we've got to address that when we let someone be a sponsoring broker, it's a different thing. It's a different world. And I think that we at least ought to have a discussion about whether or not we can in some way, shape, or form regulate that. That's just my thought.
Do you think that we can fit that discussion under agenda item 7 today?
I think we can at least talk about it. Yeah, I do think we can.
All right, let's put a pin in that then, and we'll do that. Thank you, sir. Soccer, did you have a comment?
Yeah, I was gonna talk about the fact that if you are one of the things that we do that we're doing currently is if you are just me and I decide I don't want any agents, all my agents goodbye, then I don't have to take broker responsibility. But when I become an office that has 5, 10, 20, 50, 200 agents, I'm required to take broker responsibility every 2 years. And it says in the broker responsibility training, as we all know, because we've been through it, is that you are supposed to have mentors for people. And these comments, you're supposed to, in the essence of the law, the salesperson is the apprentice to the broker. And when they enter into you know, any transaction from them first starting out to them changing their competency or geographic competency, they're supposed to be paired with you, the broker, or someone else in the company as a mentor. So I don't know.
All right, let's hold that thought till agenda item 7 as well, because that's going to fit right into that discussion. Mr. Williams.
You know what? I can hold mine till the other agenda item as well, but I'm going to go along with everyone else here. I'm in agreement. Need to address it.
Oh, for sure. Commissioner Lerner.
Pertaining to what Soccer just said, I know there's also been a discussion for broker responsibility to be taken by all licensees. So we still need to continue that discussion, that being part of a prerequisite, just so the agent will know what to expect from their broker. But on another note, and I've talked to Mike about this as well, if you have an associate broker within your company, it's a really hard fine line to figure out who is really in charge, so to speak, there, and who is responsible for that associate broker's activity. Also, right now, our TREC website does not even show that a broker is associated with a company, which if you're looking to say, okay, you're doing something wrong, you don't know who to go to unless you do some digging. So I think that's all something we can package up in that discussion.
Sounds like a plan. Okay, moving on. Oh no, no, Leslie, your hand's still up. There we go. All right, so moving on into that, we will put a pin in that for the discussion item number 7, and we'll continue to go through. Here we've got somebody that is happy that we've taken the cap off of managing transactions. So that's fantastic. I think that this person also did not read that there is a management rule that no longer has a cap on it. I would think they would fall under that rule in this role, but that would be for their broker to attest to. And other than that, we didn't have any comment, right, Vanessa?
That was it.
So I don't see any action item that we really need to take on the proposal that we've already made. And so if everybody's on board with it, this is what I feel like we should submit as our final product to the commission, correct? Do we need to make a motion or anything like that?
You don't. There are no changes made. So it'll go forward at the commission meeting. We'll address those comments in the preamble and see what happens.
All right, very good. So, seeing nothing further, we will move to agenda item number 5, which is the discussion that we had previously on written draft rules regarding property management. Again, I will preface the discussion by saying that this is going to be covered by the commission under their rule review. I don't know that it's in our wheelhouse to try to suggest something like another type of license or anything like that. I know that we had asked the staff to come back to us with some information on the previous discussions on this, so I'm going to turn it over and let
Vanessa, do you want me to take
Jennifer
a little intro on this? Okay.
Yeah,
Good morning,
yes.
everyone. Okay. I'm Jennifer Wheeler. I'm the Director of Education. And just a brief overview, the information in your materials. At the direction of a former executive director, ESAC was tasked with considering certifications for property management, farm and ranch, and commercial practice. This started in 2016, 2017. ESAC started with property management, and over an extended period of time and discussion landed on the concept of a voluntary certification. As you can see in the materials, rules were drafted to include an education and experience component as well as a certification examination. There were two proposed pathways. One was more experience-based and the other was more weighted in education. Just for some historical context, the work took place in and prior to 2018, and then significant shifts in directives and priorities came as a result of the Sunset Review, and as a result, these draft rules never made it before the Commission. They're before you. They include some preliminary research that was presented to ESAC based on what other states do. I think at the time the research was performed, there were 6 other states that had a property management license. There were some that have, I think it was called community management license type. And then also included in the materials were an overview of the existing external property management designations that are available. So with that, that's again just a brief overview, and I think Lee has his hand up.
Yep, Mr. Warren, if you'll give me just a minute, I was going to ask Mr. Baker, because I believe that he was on the broker responsibility working group when this was being discussed, if he had any historical perspective that he would like to throw into Ms. Wheeler's comments.
Yeah, with Commissioner Brown's, with your permission, we the big thing that came out of that, and Jennifer is right, it was a voluntary thing, but the concept was if you're going to advertise that you have that certification or that expertise in property management, that you had to meet certain TREC guidelines. That's kind of how I remember it, Jennifer. Is that what you recall? That we didn't say here's a mandatory thing you've got to do, but kind of like, you know, when attorneys say board certified and we do this, that, and the other. If you as a broker or a license holder are going to say I've got expertise in property management, you've got to meet certain requirements from TREC, and I think that was the gist of what we ended up coming up with. And you're right, several of the things that we proposed got kind of waylaid by the Sunset Commission. And so, but that was, to me, that was the primary function of what we considered. And I still think that's a valid thing, that providing an avenue for people to gain those certifications other than the ones through Texas Realtors and CRM and et cetera and so forth, that if you're going to advertise, you've got that expertise, then maybe TREC should say, okay, you've got to meet certain requirements. That was our thought.
Thank you, sir. Mr. Warren.
I can see where there's a number of different rules for different states as they relate to property management. In looking through them, I can see pros and cons between them all, but in the end, we're a consumer protection agency. The whole reason I kind of brought this up from the get-go is to really discuss that. Through years of disciplinary actions by license holders engaging in property management, there seems to be an obvious demand for action to be taken in order for us to protect consumers, which include both property owners as well as tenants alike. I know the governor's directive with the Sunset Commission was to not introduce roadblocks in getting into the industry. So I think that what was talked about previously is not something that would work. I think that would kind of go against that. Not to mention, I think doing a voluntary thing like that doesn't fix the problem, because it's not the people that would actually take the time to volunteer for those classes to do that are actually causing the problem. The people that are causing the problem are not those people that are willing to go through and voluntarily take the extra education. So I don't think that would actually fix the issue anyway. We have a clean slate to start with. I mean, we can try and piece something together that conforms to what other states do, or we can look at the possibility of setting a new standard by which other states may look to, you know, in the future. We know that license holders are required to have competency in the field that they plan on serving, and I think we have a good baseline education for the sale of residential property with the required pre-licensure courses that are already in place. But there's nothing that required of a license holder from an education standpoint in order for them to engage in property management. I think requiring a specific property management license I think would be great, but probably not going to happen. we have to look at something else. So what I had discussed previously was, I think we already have a system possibly in place to at least start moving in the right direction. So in order, and that's the designated broker listing that's there on the website for everybody. So in order to be a designated broker of agents, you have to be a designated supervisor, a broker, whatever, or a designated supervisor. I'm just talking about creating something similar for that for the property management, designated property management. And we can set up requirements for that, just like they do with the broker responsibility course, so on and so forth. This is not to be confused with obtaining a designation from a trade association, though I think the requirements in order to obtain such designations are more in-depth and recommended. I think we're talking about here is something a little more broad and just a little simpler. By leaving the trade association designations alone, this still keeps them as a value-added education benefit for the license holder as a way to obtain or increase their knowledge for property management. For our purposes, we could create, say, a 2-day or 16-hour course to go over all the basics of property management. Though this wouldn't be an end-all be-all by any means education on property management, I think at least it would give a good solid baseline of knowledge before someone engages in that area of real estate that creates arguably the most complaints of all. We can cover topics like in that 2-day course, the residential lease, property management agreement, property code, trust accounts, property management accounting, eviction, security deposit, risk management. Those are the areas that seem to be hit the most when it comes to complaints. So just keep in mind that my thought process for this is just for 1 to 4 family units. I don't see, based on the complaints and things that I've seen in the past, that applying this to commercial or apartments would be warranted in any way. I believe the risk to consumers is clearly more on the 1 to 2 person license holder that practices property management as opposed to commercial or apartment management, which tend to have much larger companies that specialize in such practices. The designated property manager will be required for any broker or salesperson that would engage in property management activities for 1 to 4 family residential units. Brokers that sponsor salespeople engaging in property management but not actually managing themselves would still be required to be designated property managers since they're responsible for the actions of their agent. From a logistical perspective, in order to accomplish this, we'd need to create the course, which could be done through ESAC, and also create the designated property manager listing as we've done with the designated supervisor. From the ESAC point of view, I'd be more than willing to invest the time in assisting creation of the course. I also know a boatload of other property managers, license holders that would be willing to help with that as well, to put that together. But like I said, I don't see this as an end-all be-all solution to property management problems we have in Texas, but I see it as a reasonable, attainable step to protect consumers on multiple sides of these transactions by having a licensee that's more educated specifically as it relates to property.
So first of all, Lee, if I can, I want to take a second and just say thank you to you for really, driving this and being at these meetings and being in person at the last commission meeting, and the great job that you've done, really, bringing this to light in the time that's taken out of your business to do so. So thank you very much for that. Ty, if you'll hold on just 1 second. Mr. Malloy, just so maybe don't read the enforcement actions of the commission every single month, unless we're having trouble sleeping or something like that. Would you give some background on property management complaints, kind of what they look like, the volume, things like that?
Well, if you recall the last meeting, I did provide a chart. I mean, progressively, the amount of complaints have been going down. I mean, we do get them. It depends. It's a cyclical thing. It depends with what's going on in the real estate industry. They were big when everyone's houses were underwater. 2008, 2009 became a big issue because we didn't have a whole lot of tighter regulation at that time. The statute was changed to provide that, if you're going to be handling at least, single family residency types of stuff, you needed to have a license. So that provided a protection to the consumers because there's a lot of unlicensed property managers out there. So at least it allowed us the authority to punish people and then, go that other extra step, you had to be licensed. Well, a lot of times I see is, people that get into it, they may be inexperienced, but a lot of times, when we get a lot of complaints, it's against one individual person, so that may cause a spike. But in general, it's been the type of complaint that's been trending down over the past 5 years. We get things where the typical disputes, fail to remit money. That's not as as common. It's more they didn't handle my transaction. They didn't properly vet a tenant. But it runs the gamut. There's not really one place to pigeonhole it, so to speak. So
Okay.
Yeah.
Very good. Thank you, sir. Mr. Williams. You're muted, bud.
I really like what Lee has done on this as well. I just also wanted to say thank you to you as well, Lee, because I really think you put a lot of effort into it, and I respect it and appreciate what you're doing, because I'm a firm believer in what you're doing as well. So what I will say is I really like the concept of a quote checkbox on the website to identify who is doing the property management and who the broker certifies is a reputable agent to be doing so, because the broker really is making the decision. You could say, well, I didn't know, or whatever, blah blah blah. My point is that I think that it really makes it really kind of brings the broker to the forefront of making sure that if you've got somebody doing property management or helping you on it or whatever, that they are doing so, and that the public knows that they're doing it, and that you're certifying that they are good. I mean, honestly, I would be very cautious being a broker certifying that anybody could do property management in the first place, but this would really make me worry, honestly. And I think I would be holding them at a lot higher standard, because I know that I put it out there. It's on advertisement. I'm letting the public know that this is exactly what's going on, and this is the person I'm telling you knows what's going on. This can also affect something that hadn't really been brought up, but I think it really makes it could be another valid point, would be fair housing issues, right? Just because TREC doesn't have a complaint on it, there still could be a fair housing issue that TREC doesn't know about, that there's investigations on or what have you, but it could help in multiple different ways. And I see it here in Fort Worth all the time. I'm telling you, I get calls from agents from outside of my brokerage, or people just needing help on issues with their property management company. And I think this would be great, because it is hard locating people sometimes within a brokerage. The designated supervisor thing is helpful as well. So I really feel that this is a good thing for us to at least look at. And I think that ESAC also could lead the charge on putting together a great class that we could have go alongside this certification or what have you. And I think it just gives more transparency to consumers, more transparency to the people in the industry, and quite frankly, more transparency to people that are getting their properties managed by brokerages. So I think it's a real positive. So I'm right along here with you, buddy.
Thank you, sir. Mr. Sales.
I think they're great comments, and I appreciate what Lee has done as well. I want to mention that Texas Realtors has put in place 2 certification programs, one for certified leasing specialist and one for certified property management. My property managers are going through those courses, and they're pretty rigorous. And I think when they get that certification, they have completed a ton of education, and I think they're better for it. But it's totally voluntary. So while they'll get those certifications, they're doing that on a voluntary basis. And I think we could lean into that from the TREC perspective and not reinvent the wheel, but look at what those courses are doing, and then maybe look at some sort of a requirement that a property manager obtain those certifications.
Thank you, sir. Mr. Warren.
So Mr. Malloy had brought up the previous metrics that we talked about before, and he's right, it is very cyclical, which is also why the timing of this, I started to put this in right now. As we've noticed, anybody who's been around for a long time, once we see the markets go up and down, it is what it is. But we have, at or just below 170,000 actively licensed agents and brokers right now. I mean, that's more than Trek has ever seen. And just like we had in 2008, when everybody and their mother was trying to get into real estate, all of a sudden when the sales dropped and they couldn't find any sales transaction, they were looking for some other way to make money. And a lot of them started doing property management as a way to get monthly income, as a monthly income stream, and doing that. And and we had a lot of those complaints spike right around that time, when those agents who were just doing sales all of a sudden became property managers. And now all of a sudden that started a whole new trend. So my concern here, and why, that I'm kind of looking at the timing of this, is because I think we all kind of feel that little curve is coming. And I'd like to see us hopefully head this off before that curve happens again and we see another big spike in those. Now, we may not have the amount of complaints that we see is one aspect of it. The other aspect is you can ask 5 different property managers anywhere in the state if they know of other property managers that are doing things wrong, and they'll give you 20 property managers that they know that are doing things wrong. Whether it be trust accounts, typically the big one, the broker is not on that trust account like they're supposed to be. Security deposits aren't done right. I mean, there's a number of things. And unfortunately, consumer education is a big part of that too. They don't know that somebody is managing a property incorrectly as well. And I think that's a hidden component of this that we can't really find a metric for either.
Very good. Thank you, sir. Ms. Chapman-Thomas.
Hello. I was just writing it in the chat. I agree with Brian. Instead of ESAC and Trek having to create a whole nother course and all of that, since these designations are out here, then in order for someone, say if I wanted to get property management certified on Trek's website, I have to prove to Trek that I have completed this narrow group of classes that only Trek can approve for the purposes of me getting the check next to my name on the website that says I am qualified and, board certified as a property manager. So I think that would solve the issue without us having to reinvent the wheel, as Brian says. That's all.
Thank you, ma'am. As a reminder, only use the chat box for technical issues with the recording, because we can't record that for public record. So not calling you out, Soccer, but just kidding.
But
Mr. Roth.
I'm getting confused with Zoom.
I know. Mr. Roth.
Listen, I appreciate the discussion. I think it's an important issue to always make sure that we're trying to educate the practitioners out there. And I think our main objective here is to protect the consumer and to educate the consumer. And I think that's what we have to sort of focus on. And the issue to me is, and it's a question, not so much a directive, is that it doesn't seem to be, this is a different type of a business. Property management is not a transactional business. It's not a one-off business. It's a relationship business with your client, and that consumer is a business client, so to speak. And it would seem to me that if as Lee was mentioning, that the consumer or the client doesn't understand the rules and what should be expected of the deal, then I think there's an opportunity to create a program for consumer education so that they can then monitor the people that they are hiring. I don't know that, and that would then direct the industry to be able to step up to the requirements that a person should maintain to be in this business, if in fact there is a big discrepancy or a big problem. I'm not sure, and I'm not advocating against or for, but I can't understand that there is a major problem, and I respect that maybe it's not in the forefront, but it doesn't seem that there's a lot of lawsuits. It doesn't seem that there's a lot of issues that come up in the general public that I'm aware of. And again, I'm in the commercial property management business, not in the residential. The second thing is, so if it, number one, I would be cautious about legislating or getting into an area where we are not really needed to be impacting, number one. Number two, I would say that our directive should not be necessarily to monitoring or managing our agents, but to manage and inform the consumer. And when I say manage, I'm talking about making sure that they're aware that they can enforce and monitor the people that they are hiring on a regular basis. They can fire people. And I would think that that would be the greatest incentive for a property management firm, is to make sure that they're doing the right thing so they don't lose that account, because those could be big accounts. So again, I would, in this group, and I think this is something that's going to require a lot more further discussion. I would really be cautious on running to specialist programs, to running towards a legislative or licensing alternative for this situation, because I'm not really clear that there's a dramatic need or demand to weigh in on this particular area.
Thank you, sir. Soccer, do you have your hand up from previously, or? Okay, got you. All right, so I have some staff questions real quick before we move forward. I guess either Vanessa or Chelsea. The hard part of this discussion, because what Lee is talking about, I think, for those who are out in the world and see the problems with a lot of people doing things that they aren't supposed to be doing from a property management standpoint, is that he's probably right in the fact that this is almost universally a residential property management problem. Excuse me. However, there's no differentiation in licensure. And so from the standpoint of administrating a program like what we're talking about, where there's a checkbox, that would mean that Bill Roth would also have to have said checkbox and take those classes, being a commercial property manager as well. That seems problematic to me from an administration standpoint.
Yes, I think there's, I think if you back it up, it's, well, okay. I think I'm going to back it up even more than that. In talking about sort of the requirements and, certification, a license, whatever you want to call it, you're going to have to get some statutory changes in place. I never want anyone to think that there's not an option to recommend things that require statutory changes. I think it's just important to note there's a bit more of a hurdle there, right? It's essentially creating a new license type, it's expanding the regulation, etc. That's not a no-go, there's a bar to that, etc. But all these things that we're talking about, in terms of making sort of an official situation, a checkbox, that certification, that's going to require a statutory change. This group could recommend that the commission consider that when it takes a look at, the upcoming legislative session. There's got to be a lot of stakeholder input, et cetera. But that's, I think that's a recommendation that can be made. So there is that, right? That I think is it couldn't happen right now. And I think that Lee, I think you understand. I think that you say that. You get where all of that stands. And it seems to me like what you're saying is, well, what if we had, if we can't get to certification without a legislative change, what if we had a course, like a required course or something along those lines that gets people somewhere. Am I hearing you right, Lee?
Yeah, I know that doing separate licenses is probably out of the question. Trying to get that statutorily changed is a whole nother mountain. And yes, Mr. Roth, to your point, and I said that in the very beginning, I said this from the get-go. I don't think this applies really to commercial or apartments or anything like that. I completely agree with you. I think this is more 1 to 4 family residential. And yes, I think there's a certain degree of difficulty as separating that, because I don't see the reason for any commercial property manager to go through what I'm talking about. I don't think it would benefit you, nor would it benefit your clients. I think this is more on just the 1 to 4 family residential side.
Well, and the TREC jurisdiction over commercial property management, there is none. But in terms of a course, so I'm trying to see where we can have movement, right? And I think that's what everybody's trying to see. So this group, if you want to recommend to the full commission at some point when, today or later, whenever that discussion is sort of concluded, yes, that's a mountain. It's not, I don't know. I don't have an analogy for that. It's not impossible. But there.
I guess my biggest question is, if we're going to put a checkbox out there, and if I as broker have somebody who is doing property management and I check that checkbox becomes universal. Like that means that in theory, Bill would have to check the checkbox next to himself and then be required to take this course or a similar course, correct? Because he's doing commercial property management. I just don't know.
I don't think so, and I'm going to turn my head virtually to Abby. I don't think so, right? When it would come to commercial property management,
so good morning, everyone. So when we're talking about what we have jurisdiction over, property management is rather limited. And when I say property management, I'm strictly speaking about I'm excluding leasing, because leasing is generally included. But under the License Act, property management is limited to collecting or accepting rent from a single family residential property. So that's really the only thing that we currently have jurisdiction over. We don't regulate commercial property management to that extent. Now, if we're talking about leasing, that's wrapped in regardless of whether it's residential or commercial.
Right.
Okay. Well, so that solves that problem.
So
I guess.
Yeah. Sorry.
Oh, sorry. Go ahead. No, go ahead.
No, I just you have more questions, and you can please just ask them. I was just going to say, there may be some room in the course stuff. We need to dissect that a little bit in terms of required, and there's a course that's out there, as I understand from Jennifer. Perhaps that outline needs revision from the consumer standpoint. Bill, you mentioned consumer outreach. Certainly something this group could recommend that the TREC look into. We have our new director of communications is on the call, Summer, so she's listening.
Well, and we do have some consumer education from the Texas A&M Real Estate Center that is in the form of the guide for landlords and tenants and things like that. I just don't know how many landlords and how many tenants are going out there and downloading that. My guess is approximately 0. So Jennifer, can we talk about the education piece on this? I know that we can't say, hey, go take the Texas Residential Property Manager course, because that's a realtor member course to everybody. But as far as adoption of broker responsibility course for people who have a checkbox next to their name currently, if a course was developed that was then TREC approved, I mean, that's really not a hard administration, is it?
Well, I think it has some different components. The checkbox, does kind of align itself with some kind of licensing or designation is better. And so that I probably would defer to Denise a little more. But in terms of the education, I'll say that one, we have a 30-hour qualifying property management course. It's typically used as an elective or an SAE course for a new license holder. The outline for that content was developed many years ago, and it could be something that, you know, this group could ask, you know, ESAC to look at revising based on, you know, what's actually occurring in the industry today and some of the concerns that you all are expressing. So that, you know, whether required or not required, whatever this committee decides to propose, that might be at least a first step in getting some content that's more relevant to the concerns. It could be the course that Lee is proposing after it is revised. If a certification or a checkbox is something that ends up being recommended, or, you know, it could be something different. But I just want you to know that you do have this baseline out there and something that could be modified should it be appropriate to do so. Outside of that, you know, ESAC is probably the appropriate place to start any type of revision to this or suggestion for an outline for a new course. Does that help?
Thank you, ma'am. Yes, ma'am.
Okay.
So my next question before we turn it over, because we've got some hands up, would be to Mr. Malloy. So one of the things that we have heard from property managers, and, you know, just like Lee said, if you ask one property manager who are the bad ones out there, they can probably name a dozen, or people who are doing things that, you know, high level professionals in property management world wouldn't do. One of the things that we hear is that without the broker getting hit hard from an enforcement standpoint, it's not going to change anything anyway. So my question would be, if we put a checkbox next to it and somebody gets a complaint for doing property management and there's no checkbox next to their name, and the broker contends that they had no idea that that person was doing property management, what does that look like from an enforcement standpoint?
You'd have to look at it from case by case basis. I mean, pursuant to the broker responsibility rule, they're responsible for all their property management. I mean, the sales agent's property management activities. We look at their policies and procedures first, see if they prohibit it, and then look through like other things like, you know, if they've taken a blind eye to things. There was a similar situation a while back where, you know, a broker knew an agent was doing something, stopped it, but then the agent just proceeded to keep doing it and really did a good job hiding it, in our opinion. So, yeah, I think we did kind of maybe did like a light advisory letter saying, you know, there are some issues here, but it looked like you did your best and your policies, procedures, you know, tried to cover it, because, you know, while they're responsible for their actions, you know, they're still independent contractors. So there's not a respondent superior type of relationship where we can directly link that type of stuff. There's, so it's not employee-employer where, you know, we can jump it automatically, because if we need to seek discipline and they want to go to a SOA hearing, that's an argument they can make, saying, you know, I may be mostly responsible. Here's what I've done to prevent that from happening, and they just went beyond what I was doing. So obviously, people that have been previously disciplined, their excuses, you know, get thinner and thinner. So it's a progressive type of discipline that we usually handle when it comes to brokers. It's not necessarily straight out. I mean, obviously, if they don't have the policies and procedures in place, it's probably going to move towards a order, because they weren't proactive enough to prevent something like this from happening.
Very good. Thank you, sir. All right, Mr. Sales.
Just a couple of thoughts on it. You know, I'll start with my real estate sales license authorizes me or licenses me to practice any kind of real estate anywhere in Texas, whether I have competency or not. And I think if we start looking at enforcing rules with regard to property management, then are we also going to look at doing commercial or farm and ranch or land sales or new construction? There's just so many niches in it that property management is just one of those. Secondly, I think there is opportunity to create rules, perhaps. So maybe like we have a broker responsibility course required for supervisors of other agents, which is an additional license. It's just a rule that, hey, if I'm going to supervise other agents, I have to complete these courses. Maybe putting a rule in place with regard to if an agent is managing more than a number of properties or a certain percentage of his gross commission is related to property management, then that agent is required to complete the education or obtain the certification.
Thank you, sir. Mr. Roth.
Sort of in an effort to be constructive and thoughtful about, I sort of come from this direction from a consumer protection aspect. And if in fact that's where we really are concerned that the public doesn't understand what the property manager is supposed to do, perhaps we might want to consider or think about some kind of an informational property manager's responsibility notice, like we have the information for brokerage services, which basically would say that when you engage with a property management contract with somebody, that's part of something that we would ask the property manager to provide to their client, to the owner of the property. And that basically says, look, our job is to collect rents, it's to have a trust account, it's to have to take care of whatever we're supposed to do, the 4 or 5 things that the statutes require. And I think number one, that first of all puts the consumer on notice that these are issues that are important. Number two, it really does put a responsibility on the consumer, on the owner of the property and the engager, the person who's hiring us to do that, to do their own due diligence and to really check in to monitor the person. And I think then at that point, it also creates a tangential responsibility on the agent, on the property manager, to sort of live up to those general requirements, just like we do. It doesn't create a legal, any kind of a legislative requirement. It doesn't require a checkbox. It doesn't require a new license. It basically is designed to communicate to the public that this is what you should be that you should be able to expect from the guy that you're hiring. And it seems like to me that would be a great first step to determine whether there really is a big problem. With regard to the issue about monitoring our own co-property manager, if we know of people that are improperly doing stuff in the marketplace, I think that there's venues for providing notices to track for those, for people who are violating those deals. It doesn't have to come through the consumer. It could come from our self-monitoring our deal, our own members. And again, maybe that's a different conversation, but I don't think we need to be so much the police as much as we need to be making sure that we're creating guidelines for people to do the right thing, and not to legislate or mandate stuff for 170,000 people when there's 10 people out there who are bad actors. So again, I would just caution the group to consider that, and maybe direct some soft consumer marketing and communication that might be a path to educating people and determining whether this is really a significant issue.
Thank you, sir. Commissioner Lerner.
This is kind of just a general comment, and staff may kill me for saying it, but even though something may be hard or about statute or it has to go to the legislature or whatever else, that doesn't mean it can't be done. Just as Vanessa said, but you have to do some planning. So if you're thinking about changing something, then now, or the sooner than later is the time to do it, because next year is when session starts again. And we only have a limited amount of meetings every year. So my suggestion would be, if you really feel strongly about something, don't be scared to go after it. Put it in your brain and start moving towards it, because you have that limited amount of time. That's all.
Thank you, ma'am.
Mm-hmm.
Bill, I'm assuming your hand is up from when you talked just a second ago. If you'll put it down, please, sir, just so I can keep track
Sorry
in my
about
head here. No worries. Same with you, Leslie. Yasmin?
I have two questions more, just clarification. If we decide to put a checkbox on track, that requires legislation approval, correct?
As I'm hearing you guys describe it, yes, because it would essentially be a certification.
Okay. And my second question, again, just for clarification, if we recommended a course requirement like broker responsibility, stating if you are going to perform property management, you have to take this course, does that statement require legislation approval?
I'm going to generally say yes, I think so, but I think that I mean, broker responsibility is in statute, right? I think what we could do is, you know, if you want to give us a list of sort of if this group ultimately wants to give us a list of things that you want staff to look into and see, hey, you know, we looked into this, you can't do it this way, but maybe you could do something like this, or no, that really would be a statutory change. I don't want to be just sort of off the cuff. No, no, no. When maybe there's some room, some stuff is statutory, so without the change, you couldn't do it. But if as an action item for staff, you know, there's some bulleted points you want us to look into, how would that work? Could it work? What would that course look like? Would making a course like this require a change? We can do that and get back with you with certain answers versus like, oh gosh, is that in statute? Let me, you know, look at that real quickly, etc. We try and answer that to the best we can, but I think a task list might help us on this one because it's deep.
Okay,
Thank
thank you. And just my thoughts on just hearing everybody speak. I do believe it is a problem. I don't think the complaints that Trek is getting reflect what's really going out there. I do like Mr. Roth's idea of having something like an IBS that just has some bullet points on the consumer to know, like, hey, this is what they can expect, would be easy and helpful. I do believe, like, I mean, again, thank you, Lee, for taking your time to do all of this and all the research. But I agree with you. I think there has to be something that protects the consumer more. I do really think it would be worth pursuing the changing and adding the checkbox, knowing that that's going to take more work, but it's okay. And I do really like the idea of having a class, kind of like the broker responsibility, where it's like, hey, if you are going to practice this as a broker, if any of your agents are going to be doing property management as a broker, you have to take this course just like you do broker responsibility, and have the agents take that course. And it could be as simple as rearranging the 30-hour property management course that's already in place, just making it more up to date on what we're seeing. Property management is a whole completely different ballgame. I mean, even our insurance for E&O changes drastically if one of your agents performs this. So it's not your regular residential transactions. I do think it has to go kind of on a bracket on its own. And I know, I mean, it is right that then we start going into, you know, farm sales. Like, it is it could go a lot of ways and it can change a lot of things, but I do believe this has to be addressed. We are going to see problems when the market dips again. I mean, it's a trend, right? Like, we're going to see more of that for sure. So I'm very interested in seeing some changes in this.
Thank you, ma'am. Mr. Warren.
So I've been doing property management for over 15 years. I'm just the immediate past chair of the Property Management Committee for Texas Realtors. I've dealt with a lot of property managers in my time. I've dealt with a lot of tenants and a lot of property owners. Though I understand if, Mr. Roth's perspective, by being in commercial, why this kind of seems like we're just trying to beat this to death and really push this out. I do want to reiterate that my intention here is not for the commercial side, and I certainly understand the reservation by putting something in place, adding something to your education requirement that has absolutely no relevance in your business. I completely understand that. I'm always for informing consumers and letting them know. However, the issue isn't the consumers. I think the root issue is not that the consumers don't know. I think that's part of why we don't see more complaints is because the consumer doesn't know. But I think the root of the issue is the education of the licensee themselves. And TREC doesn't govern consumers, they govern licensees. And I think that's what we should be focused on. I think educating consumers is great, but when it comes to residential property management, which there are a number of problems we need to address. And if I think, but like Vanessa said, coming up with whatever this committee, however we want to see that shape out, if we can put that to staff and say, okay, here's 3 different paths that we can take a look at. And then staff can come back and say, to do A, it's going to take this, B, it's going to take this, and C, it's going to take this. At least we can go, because right now we're all kind of going crossways and talking about how things can't happen. I'd rather see us try to put a lot of effort more into seeing how things can happen.
Thank you, sir. Ms. Titzel.
Yes, I agree with everything everybody's saying, because I do agree with Lee that its market is going to shift, and I've had agents try property management before and it's been a wreck. I don't think 30 hours is enough education for someone to say, okay, now I have enough stuff to do to go out and manage 10 single family residents. I think it needs to be a checkbox, but I think it needs to be more education than just 30 hours. Because if you think about it, they take a lot of 30-hour courses and they think they've mastered the world when they get their real estate license, and they quite haven't mastered real estate yet. I do think we need to take some action though.
Okay, thank you, ma'am. Commissioner Lerner.
I know I mentioned this at the beginning too, and we were just talking about the broker responsibility class. We have talked about this in the past, about having broker responsibility required by all licensees. So when you're thinking about that course, think if that would be beneficial as well. That would help agents also know what their broker is responsible for.
Thank you, ma'am. Mr. Williams.
I would agree with Leslie on this one too. I think that's a good thing to look at. The other thing is that I think that if we integrate something in where the broker is also responsible for taking the education as well, not just the license holder, because the problem is that the license holder could be more educated, frankly, than the broker, and especially when we're looking at some of these brokers that are doing these individual LLCs and letting people just kind of run rampant with those as well. I think that would be a real benefit to make sure that they are competent in allowing someone or designating someone to actually do property management, because if you don't know it yourself, how can you designate and certify that someone is doing a good job and doing it the proper way? I mean, look, if I was going to send somebody out for property management, I'd probably just send them over to Bill and say, I'm not messing with it, honestly. So that's just me, because I want to stay compliant and I don't know enough about it to be competent yet on it, just to be completely frank with you. So I think that's something we have to look at as well.
Thank you, sir. Okay, so I think that we are at a point now where we need to come up with what the heck we're going to do with this. I think that, again, Lee, thank you for taking the time and investing the hours into this. I know that you do the same on the Realtor side of things, and so the service is appreciated. I think that there's nobody here that doesn't think that some sort of review of this or action needs to be taken. I think it's now time for us to figure out what that looks like. And the really simple thing to do here is boot it to ESAC, but I'm not 100% sure that that's the right thing to do. And in Lee's case, you know, I don't want a good deed to go unpunished by making him repeat this process with another group. So Vanessa had said that maybe we need to put a to-do list together for some review. I do tend to agree with Mr. Roth that this could become a very slippery slope, and we need to be cautious of that. And so, Vanessa, you had your hand up.
I was going to say, in real life, yeah, sorry. I'm bad at putting it down virtually. We have a little bit of a list, a running list, if you want us to read from that as the starting point.
Go for it.
Abby, Jennifer, and I've been frantically working on.
Go for it.
So here's what's been thrown out during this meeting, and then if you love all of it, let us know. If you want to strike any of it, etc. And I'm going to read, these are Abby's bullets. I will give her credit for this. We had a recommendation of a IABS-like form, but for property management. We have a question on what would it take to have a separate license, I'm going to say / certification checkbox on website that a license holder can engage in property management. I think also a corresponding that would go corresponding to the broker, right, over that person. Am I understanding that correctly?
I think it has to.
Okay. A class on property management that would be required for both brokers and agents, and yeah, that ties back to what to the checkbox. And an update to the 30-hour property management course outline, which that would be a recommendation to ESAC. And I do think, I mean, we'll come back with that, but there would be room for this group to make some recommendations too as to exactly what to think about in that consideration. Does that seem, did I get it? Did we miss anything? Love it, hate it?
I like it. And I would just add to that, you know, the things like a recommendation to the commission that ESAC look at this course are things that we can do immediately at the meeting next month. Like I have zero problems making those recommendations in my presentation to the full commission next month. But I do think that some of the stuff from a feasibility standpoint and looking at how we would do it statutorily, we do need to have maybe staff take a look at and come back at our next meeting. Mr. Williams.
Maybe Vanessa, I just was hearing what you were saying. I'm with you. Those are all really good there. I'm trying to turn off my raising the hand. But what I was going to say is maybe we word it differently for the checkbox on the website, and it would be more in line with what's there, because we're saying it's a designated supervisor. So maybe it would be actually a designation, not necessarily a certification, but you're saying we're going to designate this person to do it. So if you're a broker, I'm saying, hey, look, this is my person to do property management. If we're just saying that's who is doing it, I don't really think, in my mind, I don't think that it would be something that would be any different. We're still saying that we're allowing this person to do property management. We're just saying it to the public now. Just throwing that out there.
From the broker perspective.
Yes.
Okay.
Yes, from the broker's perspective.
Okay, I think I got that in. I've got that in our running chat of notes. The thing I did not include, which I 100% should have, is consumer outreach.
Yep. Excellent.
So if I'm hearing this right, comfortable moving forward with that recommendation as it relates to a new look at the 30-hour outline. So that I will take off the list. And then the remaining, you know, we can bring back something concrete for you on each of these items. Outreach too, I think, is one that can
for sure
proceed. So,
Ms. Perez.
Why are we taking just looking over the 30-hour outline if it hasn't been updated?
Because I'm going to go. Because I'm going to go ahead and make that recommendation at the commission meeting next month. That's not something we
Got
need
it.
staff to come back with.
Thank you.
Yes, ma'am. Okay, seeing no further discussion on this issue, we're going to consider it closed. It is 11:25 and we are going to take a break. Again, Mr. Warren, thank you for the time. We appreciate it. And hopefully this is steps in the right direction and we can get something concrete moving forward. So we're going to take a break. It's 11:25. We'll be back at 11:35. Thank you. All right, if we can get everybody back, we will get back started. It's 11:35, and we will move on to our next topic, which I am going to openly admit is the chairman's privilege because I brought this one to the forefront. And I love how Scott Keshner joins right as I'm about to propose giving him some more work. So welcome to the party. Welcome to the party, Scott.
Thanks. I'm going to be here for a minute. When you do that, I'll probably hang up in disgust.
All right. So in 535, there is a rule that says that a broker must respond to a member of the public or agent within 2 business days. I would like to recommend to the commission that a rule be proposed that the same occur for agents, for any licensee, not just a broker. Obviously, it wouldn't fall under 535 because that's broker responsibility, but I would like to propose to the commission that a rule be made that an agent must also respond to a member of the public or another licensee within 2 business days.
Agreed.
Thoughts, anyone?
I agree.
Soccer?
Agreed, 100%, 100%, because people will get offers, sit on them, get an offer. Today is Wednesday, and then you look in MLS on Monday, and it shows that the offer went pending, the house went pending, and they never got back to me, the agent who sent them an offer and texted them and called them and emailed them. So yes, absolutely, 2 days for everybody.
Yeah, Mr. Baker.
I thought what it said in the rule was calendar days. Is that wrong?
No, sir, it says business days. Isn't it? Am I wrong with that?
Actually, it says calendar days.
Oh, my apologies.
Does
Okay,
it?
calendar days.
Now what I see here, under J, says within 2 calendar days. Unless I've got the wrong copy.
Nope, you're right. 2 calendar days. My apologies.
Okay. And by the way, I like calendar days as opposed to business days because we all work on the weekends. And I absolutely agree this should apply to agents, whatever section that needs to go in. And frankly, and I know we're all busy and all kinds of things going on in the world. Frankly, I think 2 days is a lot of time.
I agree with you.
I don't know that it shouldn't be shorter.
I just felt like for consistency's sake, since the rule for broker is 2, we would make the rule for agent 2 as well. Mr. Roth?
So just to clarify for me, and I'm just not, maybe I'm not familiar with this, but this is a requirement, and I'm asking a question. This is a requirement that a broker has to respond to a request from their agents. Are you suggesting that the agents have to respond to the request from a broker? What are we doing here?
No, sir. The rule states that a broker must respond to an agent or member of the public.
I don't see member of the public there.
Well, clients is what I would consider.
Okay, so thank you for, I didn't pick that up, but so
the same would be true of, so yeah, if you're looking at their sponsored sales agents, their clients, and other license holders representing other parties, to me, the same should be true of an agent.
So just as a matter of crafting the language, and I'm not necessarily opposed to it, I'm not necessarily, I just want to make sure I understand it. It would seem that there's two different, that you're suggesting two different requirements here then. It would seem like you don't want the agent to have to respond to the broker in 2 days. So you're just talking about having a separate.
In my mind, we would, obviously.
A separate line
Everyone.
item.
In my mind, obviously, it would be not under subsection E of this section because it would require a new rule.
Right, a separate line item under there.
However, the language would remain essentially the same. It would just say a sponsored or a licensee must respond to clients and other license holders representing parties in a real estate transaction within 2 days.
Did you say 2 days or 3 days?
2 days. 2 calendar days.
So you're suggesting
it would mirror the same language.
Oh, okay. I'm sorry. In K.
That's the broker has to send mail to agents within 3 calendar days.
Okay.
That's different.
Then my second question, and again, I'm asking the question just for education: is 2 days a reasonable? 2 calendar days a reasonable response time?
Yes.
For transactions and for dealing with certainly their agents, but their public also. And
I'm going to say
yes.
I'm going to say
fine.
yes, but mostly because Scott Kesner is nodding his head up and down. So
Yes.
Yes.
So there we go, Mr. Williams.
I was going to say 48 hours is definitely reasonable. And if anybody is doing real estate in the room here right now, we know that this is a real problem.
Yep.
Okay.
Agreed.
Thank you for clarification.
Yes, sir. Soccer?
I lowered my hand because Ty, we're on the same page.
Got it. Ms. Titzel?
I'm just on the same page as everybody else. 2 days is plenty of time.
Mr. Chairman?
This was 3 days until I believe 3 years ago when they reduced it to 2. So, I mean, they thought 3 was too long. Two is sufficient. Yeah, agree.
Okay, thank you, sir. Anybody opposed to this? Vanessa, do we need a motion or anything, or just roll with it? And it's going to be on our agenda next month at the commission meeting.
Hold on. You're saying, do we need a motion to make this recommendation?
Correct.
Okay. Yes, I think, if you are okay with it, I would weigh in a little bit on this.
Sure.
In terms of from the staff standpoint, and I will refer to Mike in just a little bit. There was some discussion on enforcement and how this would work in terms of, you'd have would there be a flood of complaints? Are folks, is the mechanism of enforcing prompt response, does it already live in broker responsibility rule, and are we taking that responsibility now off the broker and putting it on to the agent, et cetera? And I don't know the answer. I see Chance to see you shaking your head. I don't have an answer to that. Potentially from an enforcement side, it seems like you may have a flood of complaints that I don't know where they end up ultimately, and Mike can probably speak to that better. But if somebody doesn't respond within 2 days, where does that go? Is it sort of moot by the point it gets to us? Is it not? I mean, I know they handle on the broker responsibility side now, so I don't know. I just asked Mike to speak a little bit to that. I'm not pro against. I'm just bringing up sort of the staff discussion that was had from an implementation standpoint when we always have a few pre-meetings before this to go over stuff just to make sure that we've thought it through. And Tony, maybe you have some thoughts. I know you did in the meeting as well. Putting you on the spot. But Mike, did you have some thoughts, or am I just making this
No,
all.
I mean, I just have concerns about, I mean, from a consumer protection, I mean, we do get complaints about agents failing to cooperate or failing to timely respond. We take it from a negligence and what's the harm, you know, to the consumer based thing. If agents are just counting the clock and they don't get a response 3 minutes after, you know, but they do get back to them because they got, you know, 50 offers and it's taken them a long time because their client is sitting on them. I mean, I just don't know how often they will have to update these people. If someone says I submitted my offer, what's going on, and they want constant updates, does that 2 days restart every time they send them a text or email? There's really a lot of questions on the enforcement side. And also when I read this wording, just on a fairness, it looks like if you are not represented, if you want to represent yourself, an agent, the listing agent could basically just ignore you. Just from I'm just pointing that out from a fairness perspective. So
I agree, but my guess would be, and my guess would be if it's an agent sitting around waiting to complain on another agent, until y'all figure out a way to make that anonymous, agents aren't going to complain on each other, especially when they got an offer in. I mean, they're just not going to, because they don't want to run the risk of potentially pissing off that agent and not getting the house for their client.
I disagree with that, sir. Yeah.
Soccer.
I would say that to answer Mike's question, it does start the 2 days would start over. If I send you an offer and you send me a counter today, then I have 2 days to get back to you for my client. My client has 2 days. So we're not, Chance is right. Agents are not going to start calling Trek when somebody doesn't get back to them. This is the problem occurs when you send an offer and you never ever get an answer back, and then you see it go pending 5 days later, but you have no idea. You didn't know you were in a multiple offer situation. You know none of that, so they're not going to call Trek. They're going to call the other agent and the other agent's broker. That's how it's handled. They're not going to complain to you guys. They're going to complain to us. But if it's their responsibility, just like it is our brokers, you have to answer anyone involved in a real estate transaction. And they ask you a question, or even the public, respond to them within 2 days. I mean, it's not onerous. It's not difficult. I was in the bush in Africa, in Tanzania, and I had a cell phone and could make text. So, I mean, if I could do that in the bush watching zebras cross the street, then they can do it in Austin, Texas.
Amen. Mr. Williams. You're muted, Ty.
I really appreciate Soccer's point as well. I think that really is valid, and I was thinking the same thing. And truthfully, when I'm looking at this, I'm thinking multiple scenarios where this would be very helpful. Teams, most especially, we still run into these issues with teams. You can't get anybody on the phone. You can't get updates. No one responds. It just goes into a black hole. At least it'll hold some people accountable when they're not doing their job and they are being negligent. Mike, I appreciate that example as well. But what I was going to say is that I think everyone else is correct. We're not going to be filing complaints on people we're trying to negotiate with. But if you're not doing your job, I mean, something needs to be done about it. And after all, agents are an extension of us as brokers. So they're representing us, you know, and if we're not communicating well with them, we're not teaching good culture, and we're not doing our clients right. So if we're not representing our clients right, or if we can't even communicate properly with other parties when we're trying to represent them in a transaction, meaning buyer or seller, we're not doing our job. So I think communication is 100% key in this, and I think this is important.
Very good. Thank you, sir. Mr. Slagle.
Well, since Vanessa called me out, I just wanted to address what I had mentioned, and it seems on point with a couple of comments that have been made by a couple of members of the committee, which is essentially, I guess my worry would be if this is then punting the responsibility of the broker to the sales agent, because it sounds like there's already a mechanism by which if there is an issue with the sales agent, you go through the brokers, which seems to me to be the appropriate mechanism for doing that. And then my other question just would be if there's not going to be complaints filed, I guess I'm curious as to what the change in the rule would then, why that would happen if there isn't providing a mechanism for which people could complain, because that's the whole purpose of establishing that rule, is to give a mechanism for the agency to oversee that particular aspect of the sales agent's transaction. So I just again, since Vanessa mentioned me, I just wanted to address those two things.
I think you would get complaints from the public. I don't know that you would get complaints from the agent until it was after the fact, if at all. That's just my thought. Ms. Hightower.
Okay.
Holly, are you frozen? Okay. Mr. Malloy.
I guess I just had I don't have a feeling either way on the issue. But do better brokers, I haven't viewed, do better brokers put a standard response time in their policies and procedures for their sales agents? Is that like an industry type of thing? I'm just asking out of curiosity.
Since he's next up on the list, I'll let Mr. Kessner answer that question. I don't have him in mind, I can tell you that.
We don't have it in ours. I want to just agree with what Soccer said. It's not the response, I got your offer, I'll present it on Saturday. It's you never get a response, they got your offer. And I think where this would help, Tony, if Bob could pull that language back up. It says broker or supervisor, and they're going to say, well, I'm not the broker or the supervisor. And I think it just lists them as needing to communicate within 2 business days. That to me would be the mechanism I would use with the broker and or the agent to say that, you know what, you also need to communicate. And we get it all the time. We present offers. Today's Wednesday. We're not presenting till Saturday. At least it's been communicated to me that I should expect something Saturday or Sunday. But a lot of times we get nothing. And a lot of times you call the broker and anyway, I think adding the agent in there somewhere, somehow would be good.
Thank you, sir. All right, Holly, I don't want to leave you out. We were having connection issues before. All right, Vanessa, do you want to jump back in?
Yeah, I'll jump back in. So to answer your original question, yes, you would want to vote to make this recommendation. I think it would be a new rule. I don't think it makes sense to put it in broker responsibility rule because that's sort of hiding it from the people it would apply to. So I think you could make that recommendation, and I can work with you on that to the full commission, and then we being staff will walk through that process of what that rule could look like and where it would need to go for review. I imagine back to this group in some capacity pre-proposal should the commission want to move forward with that. So yes, you would need a vote, but that would be sort of the path it would take.
Okay, so my question then to you from a motion standpoint, does this need to be the exact wording, or is this we're going to make a recommendation that wording similar to?
I'm sorry. Can you repeat the question?
Do we need to have a motion that says we're going to propose this exact wording to the commission, or is this we're going to make a motion that verbiage similar to
I think you can say that. That's fine.
Okay. Mr. Roth.
Again, I'm sorry, but in reading that subsection E, I think, and correct me if I'm wrong, and I probably am wrong, this J refers to if you're bringing in another person, a supervising broker or another broker to handle something, they have to, they're putting the requirement that they have to respond to everybody within 2 days. Is that different than what we're talking about here? I think that it's referring back to E, which is the first line says that this is, you know, they may delegate a license holder, or they may, you know, delegate a supervisory deal. And I'm just wondering, from a drafting standpoint, Vanessa, and is there probably may need to be a different, if the idea is you want all agents and all brokers to respond to everybody in 2 days under any circumstance, that's a different, I think that's different than what E and J are trying to solve. But again, I'm not that familiar with it, and I may have missed something. But anyway,
No, I don't think you.
It's just something
I don't
to
think you
point
missed
out.
anything, Bill. I don't think you missed anything, Bill. I think what we're proposing here is it's an entirely new rule, right? So this would be an entirely new rule because I don't believe that the agent portion of this could fall under the broker responsibility 535.2.
Yeah,
So,
we were just I think we just wanted to use 535.2 as the, hey, here's
Example.
where it lives in another capacity, but we as staff can figure out how we get there with a rule like this and then bring it back for review, etc.
Thank you. All right, so on that note, the chair would entertain a motion that this group would recommend to the full commission that language similar to 535.2 subsection J be adopted for all licensees.
So moved. This is Soccer.
Motion from Soccer. Do I see a second?
I'll second that.
Second.
Okay. I think we had Ty and Yasmin, both second. All in favor of the motion, say aye.
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 All opposed, same sign. Motion passes. Thank you very much. All right, strap in, kids. We're moving to subsection 7 here on the agenda. That's where it's going to get crazy. The discussion regarding mentorship when it comes to brokers and sales agents. I have this, so before we get started, if you can hear construction noise in the background, I put my AirPods in to try to minimize it as much as possible, but they're rebuilding the bathrooms in our building. And so I apologize for any background noise, but I'm trying to minimize it as best I can. I'm going to start this discussion with Commissioner Lerner because she has presented the majority of the feedback that you have in your meeting materials by asking questions in a couple of different groups. But before we do that, number one, I think that we need to limit the amount of constructive criticism of other agents, if you will, in this discussion, and really point the discussion towards how we solve this problem, because I think, based on the input that you see in your meeting materials, it's a problem. And then the discussion needs to somewhat revolve around, is this we need to create a whole different kind of licensure structure, or is this a change to the existing rule? And so on that note, I will turn it over to Commissioner Lerner to introduce the subject matter.
Chance just put me on the spot. I didn't know I had to do that.
Absolutely did.
You did. So this is something we've talked about since I got on broker responsibility a year ago or a couple years ago, whenever it was. And the main issue was, and I think we've all noticed, that there is a lack of broker oversight. There's a lack of competency within the real estate, especially residential real estate realm. So we were trying to find a way to change that so we can still be valuable to the consumer and continue to be valuable, because we see technology kind of invading our space. So in order to make us valuable and continue to be that way, we need to show that we're competent and that we know what we're doing and that the consumer needs us. So I took it upon myself to ask if what I was thinking was the same as what many other people within our industry were thinking, and it obviously what is an issue. So I believe, and Vanessa can talk more to this, that we can do something under the broker responsibility section for mentorship. And if we want something more, then it may be legislative, but we can start at what we can do now and then move forward. Vanessa, do you want to add anything?
Yes. In that, I think Commissioner Lerner, just based on conversations that we've had, may have a recommendation to the rule as it relates to broker oversight of transactions. As far as creating a mentorship program under rule, I don't think there's room there. If you want license types, if you want to create a required mentorship, etc., we're getting into a bigger conversation. Again, like I said earlier, I'm not here to limit the potential for legislative changes ever. But I just want to note what Commissioner Lerner just said, which is, where is there room for, an immediate recommendation versus a statutory recommendation? The next agenda item, I'm going to also talk about some possible routes to address this issue in terms of what you all are seeing out there and that you're struggling with. So I'm just pushing that out there, that there's some layers to this, but there's some room for rule, but not a ton of room.
As of right now, statute reads that an agent must be overseen for their first transaction. As we know, one transaction is not enough. In doing some research, many states have, or several states have rules that new agents have to have the contract that they write signed off by the broker or initialed by a broker. There's just different kind of things we can do under broker responsibility to hopefully make better agents. Chance, we can't hear you.
Sorry, thank you for that. Trying to minimize the construction noise. For the purposes of just having it up in front of everybody, can we pull up the language that talks about oversight of that first transaction, please? Thank you. Commissioner Lerner, I don't disagree with you at all. One transaction, I don't believe, is enough to establish competency, if you will, in anybody's, in the real world, in anybody's mind. Mr. Sales.
Just a couple of comments, and I certainly think it's a problem where we have both new agents or agents in SAE, which, by the way, stands for Sales Apprentice, that are unsupervised. I think that just the fact that TREC requires all sales agents to be sponsored by a responsible broker suggests that sales agents need to be supervised. And when you get to the point where brokerages are so large, or you have so many licensees underneath a sponsoring broker, there's just it's impossible to supervise or even know your agent. So while we have the initial SAE license, just the language itself suggests that there ought to be direct supervision of that apprentice licensee. And so, you know, I don't know what the answer is. It might mean putting in place rules where, you know, if a broker sponsors 500 agents, then there ought to be maybe a number of designated supervisors that make it meaningful that an agent has somebody that they can go to as a mentor, as a supervisor. So it's a difficult problem, because I don't know that you can legislate or dictate how somebody's business model runs, but I think that track can require people to be, sales agents to be supervised, and maybe step that down as that agent gains more experience or graduates from SAE into salesperson.
Thank you, sir. So on your screen, you can see that at a minimum, when a sales agent performs a real estate brokerage activity for the first time, the broker must require that the sales agent receive coaching and assistance from an experienced license holder competent for that activity. That's what the current rule states. You know, to me, the very easy solution to this problem is that we change the word first. And we put a different number there, right? And so whether it's, or we add a number in between first and time, that is a number, right? And so it's the first 3 times, it's the first 5 times. I don't know what that number is, but if we're looking path of least resistance, that seems to be the rule change that would be the most effective if in fact there was a complaint made. Soccer?
Since the national average from National Association of Realtors is like 4 transactions per year, and if an agent is brand new, they might do 4. If they're great, they'll do way more than that. But at least the first 4 times or the first 5 times that they are involved in a transaction that they need to get coaching or mentoring and assistance in my office, and I learned this from being a Coldwell banker, it's the first 6 transactions they have to submit to me or my designated or assistant supervisor. They're not designated yet because they're working on getting their broker's license, but they have to submit their first 6 transactions to us for us to review them before they send the contract even over to the client. So that's in my policies and procedures.
Yeah, ours is 5. So yeah, Mr. Williams.
Thank you. So our office, we do it a little bit different. We do 2 buys, 2 sells at a minimum, and each mentor is also a designated supervisor as well, because they are giving advice and instructing and helping and guiding. So every mentor in our office is a designated supervisor. They must take broker responsibility because I want good representation out there for our agents, and I want to make it where it's a team effort. So mentorship is important, and representing our clients is even more important. So having good education, and I think changing that number, like you're saying, Chance, is a great idea. I also think, you know, I like the checkbox idea. I think designated supervisor for each mentor and taking that broker responsibility is a bare minimum.
Thank you, sir. Commissioner Lerner?
I think changing the number is a great idea, but we have to figure out how that's going to be enforced and who is really going to do it. Because we have that one number there right now, and we know that people aren't adhering to it, even though it's 1. So we need to think of a way to make brokers be responsible for it and be able to see, make it visible to know that it's happening somehow or another. And that's why I mentioned that they have to sign off on a contract, or there has to be some other way to do it, because otherwise I don't know how it's going to be enforced. And I mean, we have all these pay-to-play places right now that just hire people to make the money off of them. They have no clue what they're doing. They have multiple LLCs all over the state. So we have to rein it in somehow.
Okay, thank you.
Mm-hmm.
Mr. Sales.
I like the direction of the conversation. I think rather than a number of contracts or transactions, we use the during the SAE period, which is a 2-year period. That agent is an apprentice and they ought to be supervised and mentored. I like Leslie's idea of during that 2-year period, the broker has to sign an offer or a contract that apprentice has prepared.
Thank you, sir. Ms. Perez.
Well, I had a question, but I think he just brought up the solution I was needing. My question was going to be, is it changing the number, but do we want to do just a blanket number, or should it be like per transaction in the sense of if they're doing a buyer versus a sell, or a condo versus a residential, or a land deal? Should it be just 5 altogether? But I do like the idea of what he just mentioned. If it's an apprentice, then it's everything you do within those 2 years. That's like something that appraisers do. Their apprentices, they have to sign off and look over every single appraisal while they're being in the apprenticeship. So if we incorporated something like that, it might be more doable.
Vanessa, because I know that I can tell from your face that you want to say something. Please go right ahead.
Well, I mean, we can't do an apprenticeship, right? That's you're creating another. I don't know that it's another license type necessarily, but you're definitely creating a layer that you would need statutory authorization to do that. It does exist in the appraisal world. I think from what I hear, it's complicated in the appraisal world. Maybe that's more the required mentorship as it is, but I think heading in the direction.
Do you mean to speak to that, Vanessa?
I can, yeah. I would just say before you do, heading in the direction of an apprenticeship requires something different, and I don't think you would want to do so sort of in a subverse way too. You can speak to that, Chelsea. I'm sorry.
Well, no, I just wanted to mention that on the appraiser side, there is an apprenticeship period, and there are areas of the state where trainees, they're called, cannot find supervisors to allow them to be an apprentice. It's a significant challenge in the industry, and there is a need for more appraisers in the industry, and that is a barrier. And that's a very small license holder group. The appraisers in Texas are around the 6,000 range, whereas sales agents and brokers are more like 200,000. So I would be wary of looking to that field as a model simply because there are significant challenges. But the SAE license, of course, I mean, the word apprentice is in that license. There's already kind of a mechanism for some of that within the sales agent license, but figuring out a way to put teeth on that is probably what is more necessary. Anyway, I just wanted you to know that it's not a perfect world in the appraiser industry, as you well know.
Yes. Yes.
So we don't have to call it apprenticeship if it's going to be very complicated just to use that word. If we just change the wording on what's currently there, instead of saying first 5 transactions, just going in both, would it be very difficult to say within the first year of transactions? Or is it just like Soccer said, if the average is 4, do we just say 5? I don't know, just kind of thinking out loud.
Thank you, ma'am. Commissioner Russell?
Commissioner Russell,
you're
you're muted.
You're still muted, ma'am.
I've heard realtors in larger offices say they have to have certain documents with their requisition to get paid, or they don't get paid. Their office just requires certain documents. Is this not something that you could just have in order to get paid? You could put in there that it is tried off with the suggested that they have a person that is more qualified check their work before it's turned in. That way you would know that they have talked with someone else. Is that, I've never been in an office that large, but I do know that there are offices that you have to have certain papers to turn in to whoever is the one that pays. And couldn't that just be something you have to?
You certainly could. Yeah, I mean, you certainly could. It's just, how do we put that into a rule would be my question more than anything. And how do we put a lot of this into the rule? Like Chelsea said, putting teeth to this is the part that's the hard part of figuring that out, right? Because I know, like in my brokerage, there are a certain set of documents that have to be turned in with every transaction, or we will not issue a CDA. But that differs very, very much from our new licensees. So our new licensees are assigned a mentor agent for their first 5 transactions. And like Soccer said, and I think Ty said also, before they can even send that document to a consumer, it has to go through a review from that mentor, because we want to create a safe environment for them to fail forward, right? And that does that for us. Now, that may not be the right thing for everybody, or 5 versus 6 versus 4 versus, I think every broker is going to run that differently as they see fit. But I still think 1 is not enough. All right, let's go. Mr. Williams, you had your hand up first.
Yes. Okay, so I do agree with you on that as well. I think if you get to the point where you're getting paid, you've already screwed up. So the problem is that if you're like submitting documents for a CDA and then the broker reviews it and it's already gone through the transaction, you're to the point where, oh man, you left off, third-party financing addendum, and now these people are out of luck, and you've lost them $10,000 in earnest money. It's not going to close, or you forgot to send it to the lender and even start the process of getting a loan done. I think it goes beyond just processing paperwork. Signing off on it certifies. I think it's a great idea. I don't know how hard it would be. I don't see why it would be a big deal. And I don't feel like it's really creating any barriers in my mind. I think it's just called compliance and making sure that, somebody's being held accountable when they're new. Just like any other job, you're on a probationary period. And in my mind, a 2-year apprenticeship, which we won't call it that, even though it's called that in the license, education, basically. Really, in my mind, your probationary period is your 2 years. And in my office, I think it would be great to be able to say, hey, for the first 2 years, you're going to be working with a mentor. That's just the way it goes. Sorry, it would not be, I would have no bone to pick with it, because I want quality out there. I want to raise the bar. And if we've got 200,000 agents out there, that's a lot of agents making a lot of mistakes. Hopefully not, but hopefully everyone's being mentored, but we know that's not true because we're having this conversation. So, updating IABS, showing a supervisor, I think first key, you can do enforcement on that. I think we were talking about how do you put teeth into it? Well, if you're being mentored, your mentor's name should be on the IABS. If they're a designated supervisor, should they not? So that's one piece of enforcement. So that person's accountable for your first 2 years or whatever, first year, whoever's on your IABS for that transaction. Next piece is it, if you want to go down the route of somebody signing off on it, maybe having a supervisor sign off on your paperwork, fine. In my office, that already happens. So it's not imposed on me though. So I'm doing this voluntarily because I think it's the right thing to do. There's a lot of people who don't care what the right thing to do is. Just throwing that out there. Or there's some. How about that? We'll just say there's some people who don't care until they're caught, at least.
Correct. Thank you, sir. Mr. Baker.
Okay, I agree with the intent of where I think we're going with all of this. It appears to me that we're dealing with two basic issues. One is the number of transactions. And I noticed in all the comments that we have here on the questions that Leslie brought up, or Commissioner Lerner brought up, sorry about that, that there were a lot of conversations about maybe not number of transactions, but time frame, and that 2-day or that 2-year time frame works. But so I think one, we address, we want to have 5 transactions, we have some number in there, and the other is some mechanism of language so that, and I would think, and Vanessa, you can clarify this for me, I would think that we could somehow work through the language that we have about, you know, the minimum required in the first transaction, changing that number, but create a mechanism where the broker has to sign off or approve whatever the number is, that the broker or the broker's designated supervisor, give them some latitude there, has to approve that. And I think the other things we're talking about kind of comes to what Mr. Malloy was talking about earlier, as when look at a complaint, that they look at the broker's policy and procedures manual. And I think that's where the broker would address that. The broker would address, as each broker will have a different policy, the first 3 transactions, 10 transactions. One of my offices, we have free coaching, the other office we don't have. So it's a different situation for each broker, but I think we can create a mechanism in this section where we have either a number of transactions or a timeline, and then we have a mechanism where the broker would actually be required to approve in whatever mechanism that makes sense. Vanessa, is that just a simple language change to cause a broker to have to be responsible in this particular section we're looking at?
Mr. Baker, before she answers that question, can I ask for just a point of clarification?
Yes, sir.
When you say after the first 5 or first whatever number it is, have a broker approve, walk me through what that would look like.
What I would say is, at the beginning, in the first transactions, 1, 3, 5, that those transactions, and I absolutely agree, before our buyer signs off on an offer and it goes to the other side, before our seller accepts the counter, that has to be approved. That has to be reviewed. That has to be approved. It has to be approved by the broker or their designated supervisor. So during that process, not an after the fact thing. I think we've got to get the broker involved at the very beginning of this. Whoever said it, if we're not dealing, hey, Brian, if we're not dealing with this until it's time to get paid, it's too late. I mean, it needs to be done before this thing goes to bed. I just learned of a transaction with that Zillow contract I mentioned earlier that I didn't even know about it until it had already been executed. That's too late. My philosophy is permission rather than forgiveness. So that's kind of where we try to go with that.
Thank you, sir. All right, Vanessa, did you want to respond to that before we move down the list of hands up?
Yes. So here's what I'll tell you. When it comes to the transactions idea, that is something that we as staff had met about, and I think, you know, putting in, we keep saying the number 5. I don't care if it's 5. I'm just going to keep saying 5 because it's an easy number. You know, 5, I can see that rule change. You know, we have the number 1 right now. When we start tying it to SAE or to a time period, it starts to feel more apprenticeship or sort of junior probationary license. I have not thought that through or had the discussions on that topic to give you a certain answer. That's something we can look into and meet about as staff and look into. I think, you know, there's some other, like, practically speaking, what does that look like? What is it, you know, is it a new agent to that broker or is it a new agent? Are you seeing, you know, is enforcement seeing issues are the enforcement issues tied to the new agents? What, you know, where are we seeing where are the problems and the consumer harm and that kind of topic, and how would we implement it? And I'm not saying that that doesn't exist. I'm just asking about it. I also just realized that I'm not on camera. Sorry. I think I thought I was muted before, but I was off camera.
No worries. Okay, thank you. Mr. Roth.
I'm also just trying to understand the issue a little bit more. And my question is that it seems like to me that Leslie brought up a different issue, was that the broker oversight or the broker mentoring issue in some of these online or electronic or not, you know, sort of unusual business models may be something that's more or a specialized issue that maybe needs to be talked about in terms of supervising the people that are acting in those capacities. It seems like to me that in the discussion here, just among us all, that most people have a formal or an informal approach of really supervising their agents to do a good job. I mean, it's not something that's mandated, but it's something that's encouraged and is good business practice. And I think what the statute seemed to say to me when we just looked at it, that these are just minimum requirements that we're suggesting that the broker has to comply with in order to do their job. It doesn't say that it's the only requirement, doesn't say that it's the maximum requirement. It says that it's a minimum requirement. And I think what it does is it sets the tone and it sets the opportunity for Trek or whoever to encourage the brokers to be more diligent in their supervision and to help create, and even the trade organizations to create opportunities where there's non-statutory requirements to help manage and promote better practices within brokerage firms. So again, I'm not opposed to us encouraging everybody to do a better job and to do the right thing. But I think there may be two issues here. Are we not doing a good enough job for our brokerage, sort of traditional brokerage houses? Number one, but then second of all, is there a different issue that's being sort of brought up because of the change in business practice through these electronic or these national groups that are sort of more you know, non-hands-on, more administrative type of brokerage companies? And I really am needing to be educated on this a little bit better.
You're muted, Chance.
I was going to say the good news is that I thought Mr. Malloy had his hand up and was going to educate us on where those problems were. Now he's got it back up. All right, we're going to take it. Go, Mike.
Well, I mean, we don't see a whole lot of complaints from first-year agents or first couple of years. I don't know. You know, I would have to run a report to find out for sure. But I mean, a lot of stuff we do discipline is people have been in the industry for a few years. I mean, they get a little more comfortable. I like. I mean, a lot of this discussion in general. I mean, the more that people are shepherded along in this industry with competent brokers, the better they can become. You know, long run. Only thing I see issue on the 5-year thing is where if they switch brokers after they maybe had like 2 transactions, is the next broker, maybe better brokers probably ask like, what's your portfolio? I mean, how much stuff you've done? But these mega brokers, I seriously doubt they ask that question. I mean, I don't know for sure. So there is that back end to make sure they're getting that 5 or whatever minimum that we, that this group feels is appropriate.
Thank you, sir. Commissioner Lerner.
Yes, I wanted to talk about two things. One thing, we keep tying everything to complaints, and we know that people don't make complaints. Agents are not going to turn agents in right now. There's just no way to do that. I mean, there's just too much retaliation, and it's talked about all the time. So that's one thing that we really can't tie it to. And the other thing is we have to think about if we do the number of transactions or we do the time of SAE, either one, if you have an inactive person or somebody that gets a license and puts it on inactive, or during those 2 years of SAE, they don't do a transaction, then what? So we're going to have whichever comes later, whether it's the 5 transactions or the 2 years or whatever. We need to think of some sort of language that encompasses all that line of thinking.
Mr. Williams.
Sorry. Okay, so I'm with you on that as well. I think that the key is the number. Just as we do it at our office, we say 2 buys and 2 sells is what we do. We're more specific because I don't want you to do a bunch of buys and then you don't know what you're doing on a listing. So those are really important things. And transactions. What is a transaction? If you want to look at it, I think it'll be interpreted by a broker. If we would get more specific, I think then that's when we run into issues. So you kind of have to make it open. But my thought process is here, there's 2 things. And I agree on the complaint thing. I can't stress enough that there's been plenty of times where I could complain about somebody, but I complain to their face and say, hey, look, you need to be schooled in this. And I walk them through the process on how to do it right, because that's just who I am. And I think a lot of people do that because we want to help each other and we want to see each other rise, to the highest level you can, even if they're not with our firm. But my point is that what you do is you'll see an email come through on that someone makes an offer. I'll give you a good example. Someone made an offer on a property here, and literally this just happened. They sent an email saying, here's my offer. And we're like, okay, great. Where's your paperwork? And they're like, oh, well, this is my offer. My client wanted to make this offer. And it was literally an email I looked up the agent. It was a brand new agent. I called her and I said, hey, look, here's how you do an offer. She's like, oh, I don't even have zip forms yet. Or whatever, just throwing it out there as an example. That's one thing where it's like, okay, she just didn't know what she's doing, but she's not representing her client well, and her broker's not representing her well. So the point is it when a complaint does come up and these things are not met, because if we ask for paperwork or whatever, they're not going to be able to provide transactions that they've done 5 transactions of. If they lie to the broker, then the broker doesn't know. And they say they switch brokers or what have you, and they go to a mega broker or whatever. Yes, that could slip through the cracks. But the point is that if we're going for the right thing and we're trying to do the right thing and it's clear somebody's just trying to be fraudulent, that's a totally different deal. And I think that's what we're looking for, is to give the brokers that want to do the right thing and the people that want to do the right thing and want to learn, give them the tools to make sure that we can enforce it in our offices and say, hey, look, I know Joe Bob down the street's going to let you go through with no mentorship and you'll pay whatever. But here, we're going to put you through a real program and you're going to learn something, and it's required by law. Or it's required by the commission, however you want to say it. The point is it's giving us the tools and giving them the tools and letting them know and reinforcing the fact that education is super important, that you are going to be, talking to a true mentor for your first 5 transactions. I think 5 transactions is a good number, honestly. 4 would be the bare minimum. But just in my thought process, that's exactly how it should work. And the other way to track that is if we do the designated supervisor thing. Just because they're not running a team, they are managing people because you're being a mentor. You're managing the expectations. You're managing the process. Whether you're their direct manager or not, you are supervising the transaction. Therefore, you are a supervisor. Therefore, a mentor should be a supervisor. Just throwing that out there. So, I mean, I think these are all really important things. I am super passionate about education. I'm super passionate about raising the bar and making us look good to the public and making sure that we're representing the public to the best possible ability we can. That's what I've got to say about that.
Thank you, sir. So I tend to agree. I don't think that a time limit is the right thing here. I think it's a number of transactions. I think that makes more sense and you know, anecdotally, for whatever it's worth, because we've been running this type of program inside of our brokerage for the last 6 years, we feel that when we have people who have done 5 transactions, and we don't count rentals in that, just for whatever that's worth, you know, when they've done 5 transactions, we feel like they at least have the base amount of knowledge, and it isn't like our mentor relationship just instantly disappears once they hit 5. They still call their mentors, you know, or now they know who to call because we have a transition period out of that. So I think this is something worth having a deeper look into. But for the sake of playing devil's advocate and realizing that 14 hands are going to go up as soon as I say this, for the sake of playing devil's advocate, if we ask somebody to sign off on a contract, if we ask somebody to do this or do that, and we're not getting complaints, you know, if a tree falls in the woods and no one's around to hear it, does it make a sound? Right? If I as the broker am by statute required to sign off on a contract, but there's never a complaint, does it, I mean, is that teeth? Is that enforcement? What are we doing there? Would be my question. So, Yasmin?
I think to answer your question, I think it's a little extra step of, hey, we have to do this. And I think the majority of people will start doing that. So even if we don't hear about it, I guess it's a good thing, because that means, again, at the end of the day, the consumer is who we're protecting, right? So if there's that extra layer of responsibility of like, hey, this is mandated, I have to do this, I have to sign off, and kind of what Ty was saying, when it goes to other brokerages that have the broader, bigger companies, and you're recruiting agents yourself, and you're telling them that in your brokerage you have to have this mentorship that this other companies may or may not have, but it is a requirement that they have to do it. It helps the brokers that are trying to do the right thing have like a little bit of power, in the sense of like, hey, whether you like it or not like you can go down the street and not have this, you have to have it, because TREC is telling us that it's our duty to have this mentorship program. And at the same time, at the end of the day, we're protecting the consumers. We're definitely protecting the consumers, and that is the goal. And yes, there's a lot of brokerages that are doing it right already, which is great. I mean, but there's some that are not. And I think this isn't going to encourage them. It's just a push. It's a little extra encouragement to do it. With the 5 transactions, what I wanted to say is, I think every transaction is completely different, especially for a new agent. We're, learning so much, everything is new. And if we do a 5 transaction, I don't think it needs to be just 5 transactions. It has to be a mentorship, or whatever we want to call it, of 5 transactions per deals, meaning like you have to have help or supervision when you do your first 5 condo deals. You have to have supervision when you do your first 5 listings. And every transaction is different. If you do a land deal, it's completely different. So you should have somebody supervise your first 5 transactions on that. I don't think 5 transactions in general will kind of help what we're trying to do, if it's that making sure that the agents really, really, truly know what they're doing so they can better serve the consumer. Just my thoughts on that. Chance, you're muted.
Man, you'd think we would figure this out after a couple of years of using these virtual meetings, right? Commissioner Lerner, sorry.
I just going back to what you said, if we don't have a rule in place, we have nothing to file a complaint on or nothing to enforce. So something has to be in place to go back on when we do get that complaint.
Okay, thank you, ma'am. Mr. Sales.
A couple of thoughts. One is, you know, we're talking about what we do in our brokerages, and the participants in this work group are responsible brokers who are running businesses and supervising their agents. But I have come across agents who literally do not know the name of their broker. It's somebody in Florida or it's somebody in San Antonio. They literally don't know the name of their broker. And putting a rule like this in place where a broker or mentor or I like designated supervisor because we already have that piece in place, has to sign off on a number of transactions or during that first time period, kind of forces that relationship between an agent and their broker or their brokerage or their designated supervisor, where it's not happening in many places. And so I think it not only helps that agent, but it forces the relationship. And I think forcing that relationship is consistent with the TREC mandate that agents be sponsored by a broker. I mean, why do they have to be sponsored by a broker? So that there's a level of responsibility. And so I think what we're doing is consistent with the intent of licensing in general, but I still like the idea of during the apprentice period rather than a number of transactions.
Thank you, sir.
Thanks.
Mr. Williams.
Okay, so the one other thing that I'll say is on this topic that I think is really key is truly looking at, we're bringing new people in that are just out of school, just getting their classes done. They don't even know where to begin. And if they don't know where to begin for themselves, how do they know where to begin for their clients and things like this? But my point is that I think when it comes down to, you know, if a tree falls in the woods, does it make any noise? I think the point is that there's a lot of noise being made. And I think it rolls right back up to what we were saying before, is that agents are not reporting agents, and we're seeing this stuff all the time, and brokers aren't reporting brokers, you know, and maybe you're friends with the other broker and you're like, hey, I don't want to hurt this guy or whatever it is. My point is that if we've got these things in place, it's a responsibility of the brokers to do these things and to make sure that these things are in place. And it gives us the tools, and it gives the people who really haven't wanted to do it because they wanted to save money or whatever they're trying to do, it gives them the initiative to get those things done. And it ups the bar, ups the level of the entire industry because we're pushing for those things. There's another thing you can say is that there are large mega companies out there, and then there's the smaller companies, and there's the mid-sized companies. And what I will tell you is there are different companies out there, and I've had one complaint that I called on a broker to call first, because before I filed it with TREC, I called the broker and never got a call back from this gentleman, and never ever responded. And it took weeks before I sent him an email, sent him text messages, and finally got back. He's like, oh, I'm so sorry, I've been out of town. This guy is a broker of like 2,000 people. And, you know, that just doesn't seem right to me. And part of this is educating yourself on being a good mentor as well. It's a two-edged sword. We're not making it hard on the agent. You're really building the capacity and the quality of the people teaching it as well. So when you're teaching it and you're talking about it, you're upping your own skill. So what I'll say is maybe there's another thing we could tie it into competency. We could tie it into the designated supervisor. You can do a three-way where it all kind of ties in together. I don't know, Vanessa, maybe, you know, you're the brains here. You tell us what to do, because I think that there is a real need for this, and we can tie it in. We don't have to go in and rework the wheel, but we tied in multiple levels where it all just kind of ties together and the glue comes together.
So just to be like maybe annoying, to tie what in specifically?
to tie in the enforcement piece of requiring some type of mentorship for an amount of transactions or a time frame, and then also designating the folks that are going to be the mentors as being designated supervisors, and making sure also, just throw this out there, it goes back to Yasmin's point of every transaction is different. Yes, every transaction is different, but there's land transactions, there's commercial transactions, there's different things like this, and making sure that they've had mentorship or competency, and maybe it's somehow we can tie those both in together where it hits all these points that everyone has kind of talked about and that's important to them. I hope that makes sense.
Kind of.
It's just it's a tangled web.
Yes.
I mean, transactions we're talking about, right? Putting
yes.
like the concept of putting transactions in the broker responsibility rule. Then you, I mean, Commissioner Leonard just said it. It's in rule. You've got something. It's concrete, right? That seems
right.
measurable, documentable, for lack of a better term, et cetera. As far as I'm not sure I totally understand and maybe you can expand on it a little bit, this
sure.
conversation about the designated supervisor as it relates to mentorship.
Yes.
So what he's saying is that whoever is providing that oversight for X number of transactions would need to be a delegated supervisor.
Maybe okay.
If it's not the broker themselves, right? If it's the small brokers, yeah.
Exactly.
Correct.
Yeah. I mean, if you've got 10 people or whatever it is, that's an easy thing to do, you know. But the point is that we're by doing this, we're addressing all sizes and all forms of brokerage.
Correct.
We're not leaving anyone out, because the fact is,
so if the person
2,000 people can't call one broker, and if you do the math on it, do the math on 2,000 people, how much time would they get in a 40-hour work week with that broker? It's impossible. Mathematically, they get no time. So if you just do mathematics on this, if we say we don't even have to require how many designated supervisors, they can do the math on that and they can figure it out. The point is there needs to be points of contact. And remember, when there's a TREC complaint, doesn't the designated supervisor get included in on the complaint if there is one besides the broker? So to be the agent, the supervisor, and the broker,
yes.
Correct? So therefore, there's accountability on all levels here, where the mentor is making sure that they're doing the right thing on the transaction. They're involved in it because that's a true mentorship. It's not just coaching. This is true mentorship. They're involved, the broker's involved, and then they do the sign off on it because they're going to have to, because they don't want any issues. They want to make sure that they're covered. And then the agent themselves is working with somebody and they're trusting, and say they move companies, whatever. These are just scenarios. But my point is, let's just stick with one company right now. This is what we're looking at, and this is the baseline foundation of it. And competency, then I guess that would be your next question probably, but competency also requires education. So making sure that that person is educated on making that offer and educated on that type of transaction. Maybe they don't have the education on it, but their supervisor does, and they're competent in it. Just throwing it out there. I'm just hoping that this somehow you can tie those things together, or at least tie some of them, 2 to 3 things together, and we can make something solid and concrete out of it that would be really useful.
Okay.
Thank you, sir. Mr. Baker?
Thank you.
Okay. I'm absolutely on board with the concepts, what we're talking about. And you know, as Commissioner Lerner pointed out, you know, complaints aren't being filed, but we need some documentation in there to create some enforceability. And I've heard several of you say, Brian, and some others, that of how most of us deal with broker to broker. And that's why it doesn't get to TREC, is that we resolve it and we get it worked out. I think in broker responsibility, and then adding the other language dealing with the agent, we need to have some mechanism in there that creates some enforceability for what's going to be done. But I think this also gets to something Soccer mentioned earlier about what we have in 535.2. And this will also get to a comment that Commissioner Lerner made. All the competency, all the things we're talking about, the responsibility for what the broker has to do and delegation, we've got it. It's already there. It's an education challenge. And I absolutely agree with Commissioner Lerner, if she was serious about this, I think every license holder should take broker responsibility. I think they need to know what the responsibility is for their broker, which frankly rolls down to them. I think we're really talking about an education issue here. One of the phrases that I've often heard people say is you can't fix stupid. The people are going to be bad people. None of the things we do is going to make a difference. What we want to do is give the people who really do have an interest in trying to do it right a mechanism and an understanding of, well, here's what it means. Here's what you're going to do if you're going to do it right. So those new agents who come in and had no real exposure to how the business works, when all of a sudden they look at what we've got in broker responsibility in that nice little 6-hour course and say, wow, what? There are rules? Who would have thought there are rules that we have to follow? And I think it's a whole new world. I think so. We're talking a lot of education here. And I think a big part of that's going to be the broker responsibility course. And I think adding some language in there that helps us with 5 or 10 or 300 or whatever the number is, and having the broker sign off on these, and then creating language wherever else it might be for the agent to respond. I think if we do those things, we create some enforceability. That's just my thinking.
Thank you very much, sir. Mr. Roth.
I sort of like the direction that Bob's going with. What I struggle with, I really do want to make sure that our industry is the highest level, that we're really doing the right thing, that we're training and trying to provide the best service we possibly can. But whenever we get into what I struggle with is when I'm trying to think about how do we legislate this stuff and how do we regulate it and enforce it. Yep. When you put something in a law, all of a sudden the people everybody becomes a target for liability. Everybody becomes a target for that becomes the new bar of how you can I'm not talking about enforcement from TREC. I'm talking about the general public. We create more liability for everybody in the industry and create more opportunities for people to take advantage of the law to sort of penalize good practitioners. So that's what I'm struggling with. I like the idea of soft education, soft enforcement, I call it, rather than hard enforcement, which is legislative, but is educating the brokers. I like the idea of making everybody understand what a broker's responsibility is. I think is a logical extension of that. Everybody should understand what everybody's role is. And I think that one of the greatest things we could do is encourage, not mandated education, but encourage us to help the brokerage community understand that this is better business practices, that they'll make more money, that they'll be able to be providing better services without having to. It's a carrot rather than a stick approach, and I think that that's in all of our deliberations on all of these issues that we're talking about. I'd really sort of hope that we'd be thoughtful in trying to get to the end game without being so dramatic and draconian in our development of rules and regulations and stuff. Let's try it a nice way first, and if we can't get it through it in the nice way, then we have to say, okay, we can't get people to cooperate. Then we've got to be more legislatively tough.
Thank you, sir. And Bill, I can speak to part of that, and I know that Vanessa is going to speak to part of it also in agenda item 8. On the Realtor side of the table, the Professional Development Department at Texas Realtors has in fact created 2 lines of education that are launching this year. I know I'm teaching one of the classes. I believe soccer is teaching one of them also. Am I right, soccer? Or 1 or 2 of them. That are specifically designed around areas of broker competency. And then I know, like I said, in agenda item 8, Vanessa is going to speak to the work ESAC is doing on creating some education related to brokerage as well. So, Mr. Baker.
Yes, sir.
Your hand was up, sir.
You know what? I'm sorry. I apologize. I forgot to lower it. But thank you for
Nope, that's
checking
okay.
with me. Thank you.
Yes, sir. Mr. Malloy. No? Okay. Ms. Wheeler.
Thank you. I just wanted to reiterate, I heard, several references to the broker responsibility course, and I know that Vanessa mentioned in the very early onset of this meeting that, we can take recommendations from this group to the broker responsibility writing group. And I just wanted to let everybody know that, yes, we're continuing to hear your thoughts on that. We are in the process of, on or before March 15th, we will have had to have scheduled our first broker responsibility writing group meeting. So we're taking that on in the very near future, the new version of that course. So all of your comments here are very timely for that purpose. So I just wanted to make you all aware.
Outstanding. Thank you. Vanessa, did you want to add anything to that on the education front?
Yeah, we're gonna cover it a little bit under item 8, and I can hybrid into it. But agenda item 8 is something that you as a group have not seen before. It's the idea developing either a course or areas in the existing courses to cover this exact topic, the broker-agent relationship, the different responsibilities, etc. So I'll give a little bit of an update on that and let you know about this group's opportunity to weigh in on that work. I figured that this conversation would actually segue pretty well into that because
I think it will.
in talking about what you can do in rule versus what and Bill, you just said this, what education can you get out there? Where can you get to that end? So that'll be number 8.
Thank you, ma'am. All right. So once upon a time in a land far, far away that we called 2019, we would solve these problems with beer in the hotel lobby at realtor conferences, right? And lots of problems got solved there, but now due to COVID, we don't do that anymore. We don't have a virtual beer lobby in Trek meetings, unfortunately. So I'm going to play devil's advocate once again, since we're here solving all the world's problems. So as we talk about, I'm going to sign off on this deal, or I'm going to make sure that I understand this. My compliance officer is delegated as a supervisor. We talked about if you're getting to the point where you're issuing a CDA, it's too late, right? And so really, if a document's going to go out to a consumer, it needs to be reviewed by a mentor, reviewed by somebody who is competent prior to it going out. If you say that I'm going to sign off on first 5 transactions or whatever that looks like, the question is, if my delegated supervisor who's a compliance officer checks the docs and says, yep, it's good, does that count? Because I don't know how you make a rule around that.
Yeah, this is soccer. If you have a delegated supervisor that you have trusted to be a delegated supervisor, and the rule in your office is that the first 6 transactions, 5 transactions, whatever, have to be signed off on by a broker, mentor, delegated supervisor, then before you send out your buyer's representation agreement, they look at it. Before you send out your first offer, you've spoken with your client and you have the offer together, but before you send it to your client, the delegated supervisor reviews it and then it goes to the client. The answer is yes. That the delegated supervisor would be synonymous to the broker signing off on it.
Right. So that would be my fear, Soccer, is that it doesn't get looked at until a CDA is being issued.
No. It's before that. It's before it's even sent to. It's during the offer process. It's before you even send it to your client. Your delegated supervisor has to review it before it goes out to even be sent for the client to send the offer. It's hopefully before you get to the CDA part, because once you get there, I mean, to tell you guys this, I have this new agent. She sent me this offer that she was going to send to someone. And she's been in the business for 10 years. I don't know how she doesn't know how to write a contract. I'm like, what are you doing? This isn't even, you're wasting your time. I said, you're getting on a Zoom call right now. We got on a Zoom call. I said, first of all, you cannot sell this because it is not a house. It is a mobile home. It is older than 10 years old. It can't be sold FHA. So unless they have a huge amount of cash, okay, they're not going to be able to buy this property. She didn't know that. So because the rule in my office is before you do send this stuff out, you have to send it to me. I caught it before it even went to a client and had them think that they could buy something that they couldn't. So that's the way it works in my office. And I think that that's the way this rule could work in the marketplace.
Thank you, ma'am. Commissioner Russell.
Let me try to explain my comment about having on the document they submit to be paid for. In my mind, a new agent, they're going to go over all of the forms. What do you think they're going to want to know about first? How do I get paid? How do I do this? And they're going to say, item 1, 2, 3, and 4 has to go in here. And this one is the most important one. Do you think they're not going to pay attention to how they're going to get paid if they're introduced to that right away? I just figured they'd want to know just exactly how that was going to happen. And that would be one of the very first things before they even started practicing. That was my thinking.
Thank you, ma'am. Yasmin.
I wanted to answer Barbara's question or her clarification. So for my brokerage, we have exactly that in place, what you're referring to, the DA. In order for any agent to get paid, they have to submit all the contract, all the documents, in order for us to issue that DA, in order for them to get commission. And we have to check it. If we see any errors, we send it back. So the problem with, I think, what we're trying to achieve with that is that we as a brokerage don't review it until it's the closing time, because they cannot submit for a DA until the week of closing, because there's addendum. Sometimes the closing date changes, things change, so they cannot submit it until we're past all the finance period, all of those. So it doesn't get submitted to us until the very end. So the only problem with that is that, again, we see it at the very end, but by that time when it's a new agent, just like Soccer's example, they could have already sent a contract that shouldn't have been sent to a consumer, gotten their hopes up, their clients, and the errors already happened. So what we're trying to do is supervise them every step of the way to make sure that they know what they're doing, so the consumer is protected.
It's kind of like a statute.
Yes, sorry.
No, go ahead. I'm sorry, Commissioner.
Does not their mentor go over things like that with them in the beginning? I mean, couldn't that have been introduced to them their first day at the office? This is what you need to know about.
So that's exactly what we're trying to accomplish here. Right now, there's nothing that mandates that. We do, like it seems like we said, you know, the responsible brokers have that in place. Like I won't let any of my agents submit anything until me or the other broker sees it, but there's nothing in place that requires it. So we're trying to help make it a requirement so everybody has that kind of help.
Understand.
Exactly. Yeah, because
it's
like
almost
when
it's almost like a statutory tax district notice, right? That has to be executed prior to the contract. That's the failure point, is if we're not looking at this stuff prior to the contract actually getting in the hands of the consumer.
Yeah, and I have to give my broker his props, because I started at Coldwell Banker United and Richard Smith was our broker, and our managers, they taught us before we even were allowed to talk to people. We had a 2-week training where half a day we did work and then the other half a day we like talked to people. But we had to sell houses and turn the work into our broker. Like he would go into MLS and choose a house and say, this is the house, the buyer is buying this cash. This is a house, the buyer is buying it. He gave us all of the, and it was live MLS listings that he made us go look up the taxes, look at all of that, and write the contracts and turn them into him. And then he'd cross them out just like you're in school, highlight them, put red. It should be this, this, and this. So once you were allowed to go out and be with people, you had about 20 or 25 contracts that you'd actually written for different types of properties, for different types of scenarios and down payments. And that was something that I was taught as a new agent. So like to Commissioner Russell's point, before you even go out to the people, they should be trained, but that's not what happens out there. So we're trying to do something that mandates that from a consumer protection agency perspective.
Yep. Thank you. Ty.
Okay, so just to clarify, if you're just giving them a list of things to do, it's like a checklist. They can say, oh yeah, I filled out the contract. Oh yeah, I did the IABS. Oh yeah, they may not have filled it out correctly. So we have a whole list as well. But the problem is that my concern is not whether they got to that form. My concern is whether they put the right information in that form. And I think Soccer's point of doing the mock offers and things, that's what we do too. I think it's a great practice. We can't mandate that, but I think it's a great thing to do.
Correct. Yasmin, did you still have something? Nope. All right, put your hand down. There we go. Okay. Well, what do we want to do with this now that we've had this lengthy discussion is the big question. So do we want, do we need to do some research on some things on this? I would say specific to number of transactions versus time period, we need to have staff look at that, in that issue in particular. So do we want to send this back to staff? Do we want to put a motion forward on a recommendation to the commission? Don't everybody speak at once.
If we put a motion forward, I don't think we have a motion to put forward, right? I don't think there has been like a full agreement on what we would like to see.
Yep. I tend to agree with you. I think that we all think something needs to happen. It's just what that looks like.
Can staff report back on what we can do under rulemaking and what would be more of a long-term fix? So we know where to go, and we can either have a working group or do something to get together to meet so it can be presented to the commission. So we can get things moving.
Would it also be helpful if I asked for that direction from the commission at your next meeting, Commissioner?
I think anything would be great. So.
Okay, I can do that.
I just want to be clear. I know what we're doing. So you would like for staff, we're going to look into number of transactions versus time period, which we discussed earlier. You want us to look into what would require a rule change and what would be statutory as it relates to which topics? We've talked about a lot. I mean, are we talking formal mentorship, required mentorship, this relationship between the designated supervisor and the broker, sort of that middle level? It sounds to me like we're talking about almost like a middle level of responsibility there. So it seems like a lot of ideas have been thrown out, so I just want to make sure that we as staff walk away with, like we did on the other one, bulleted list of what we need to return to you with.
So to me, based on what we've heard today, and if I'm wrong, anybody jump in and correct me, there would be on the very simple side of things, it would be changing the wording in the current rule from first time to a certain number of times, right? Number of transactions, right? So that, to me, that's the really simple side of it. I think that there's a conversation to be had based on the conversation today about making whoever the person is that is providing, whoever the competent person is that is providing the supervision or mentorship, a delegated supervisor, requiring that of that person. I think that there is a discussion of the docs going to somebody prior to them actually being executed and not just signing off on it at the end when it's already too late. And then I think you talk about, a real actual formal mentorship, which I don't think that's a realistic thing, but it's certainly worth having the discussion about.
Chance, what if
Yes,
what
sir.
if you talked about with the delegated supervisor role? Obviously, that would require the broker responsibility course being done, so that would be an element of education.
You mean for that mentor?
Yeah, for that mentor,
Yeah, I mean, I think that if they're delegated supervisors, they have to.
they would have to do it. So how can we make that? Can we make that a part of competency, or I don't know.
I mean, I think by virtue of clicking the box, you do so.
Yeah.
Mr. Roth?
I have a little bit of a difficulty in suggesting that we change the minimum requirements for under that statute, whatever that line. It just creates a responsibility for a minimum activity level. And I think once we start getting into specifics of activity level, I don't know that that's appropriate for this group. Now, so that's on the legislative side, and on the regulatory side. I would, though, encourage us to suggest that from an education side, and not a mandatory or a licensing requirement side, that we create some kind of an encouraged program or a joint program or something where we can make sure that we're trying to create best practices for agents and brokers, and that this become a topic of best practices that we would sort of try to promote without going into changing the law. And again, that's just my recommendation, and maybe that helps you sort of decide. The commission can maybe sort of say, okay, we don't need to throw out the baby with the bathwater, but let's try to address the situation where we want to encourage people to be more proactive in mentoring their agents properly.
So I think we add that to the list, Vanessa.
Okay.
I don't disagree. I don't disagree with Bill at all on that.
So education on best practices or just
best practices for mentorship and best practices for professional development of new licensees, I think.
And I can look into that. I will say, you may see me come back with a little bit more of a, we are the licensing agency from more the regulatory standpoint versus advising people on business practices. And, I think the associations probably have a bigger role and maybe reach more folks in that arena, but
Sure.
I can look into it and put something together. And I'll say, and then I'll be quiet until number 8, unless you ask me something directly. I think getting some feedback from the full commission, Chance, in your report can also inform some of these items and where we head.
Yes, ma'am. Commander?
I think it's also, and I don't know if Bill looked at it all, if you go back and look at some of the feedback we received, that people aren't feeling that they're getting what they need from the education. They're saying they need the experience. I know I've talked to tons of people that have said they've gone into a brokerage and had zero supervision and they don't know who to go to for help. So that's a very big problem. And if you look at some of these larger agencies that are coming in from out of state, they have a lot of teams, and the teams they say they will not take new agents, but if you are a new agent, you can go with a team. Well, the team leader isn't a mentor, the team leader is not a supervisor, and the team leader is not a broker. So there's zero supervision and there's zero education coming. So those are all things we need to look at.
The team leader should be a supervisor if that broker
Yeah,
doing it right. But I don't disagree with you, Leslie, in that it's oftentimes not happening because checking a box apparently is very difficult. But also, you're not wrong in that. One of the challenges as a broker when you have teams is that you're essentially creating a brokerage inside of a brokerage. And the relationship between broker and agent tends to be with the team leader and not necessarily so much with the team members. So that's always a struggle. So, okay. Vanessa, you have your list? All right. We feel good about that?
Yes, I do.
Okay. Well, then while you're unmuted, I'm just going to go ahead and call on you because it is a good segue as we move into agenda item number 8, which is ESAC's upcoming review of qualifying education course content related to the role and responsibility of broker and agent.
Okay. Hi, everyone. I feel like I have been the downer, the rejecter, the what about this all day long. But guess what? Now I'm excited about something. No, this is, I wanted to give you an update, and Jennifer can speak much more intelligently to the content component of this. But in our most recent ESAC meeting, this idea was floated it was originally floated as a qualifying education course itself. That got paddled around a little bit. There's gonna be a working group, so we'll see. But it's either this idea of a course outline or adding certain discussions related to the broker agent relationship to required coursework. So really what we're thinking about in terms of topics here is a focus on what I think comes up at every single meeting we have with this group, the broker agent relationship. What does it mean? What are you as the broker supposed to be doing for your agent? What are you supposed to be doing for your broker? What should you expect from your broker? What are the required levels of supervision? Lots of case studies, something that would really get, it would get people early, and it would be a focused discussion on that relationship and an attempt to address what's going on out in the field, if you will. So ESAC did meet, and I'm going to let Jen go a little bit more into what the topics would be. ESAC met. They liked this idea. Like I said, they kind of went back and forth on whether it's a course versus whether little bits of it get put into different required courses. They've asked for someone from this group to serve, and Chance is gonna fill that role. And the hope is that whatever comes out of that working group comes to this group for the opportunity to comment and make recommendations. There's a draft outline right now that exists. I'll let Jen speak to kind of what's on it, what the vision is, but I'm really hopeful that this is an opportunity for the education component, Bill, that you're talking about, the outreach component that we've all talked about, and looking into the topic that I know is probably the reason you got on this group. So with that, take it away, Jennifer.
Hi there. So yeah, the idea originally that was floated to ESAC was to consider, you know, a 30-hour broker, sales agent broker responsibilities and expectations kind of course. And like Vanessa said at the last meeting, you know, there was a lot of conversation had and a lot of support for this proposal. And then as the conversation became, you know, dug deeper and deeper, then the notion was also proposed that perhaps this can be accomplished by revising some of the existing qualifying courses. Originally, if we circle back to the first incarnation, which was a new 30-hour qualifying course, you know, the committee recognized that one, requiring this course for pre-licensing would require a statutory change. But there might be other avenues to get it out there. Some of the ideas behind this course, whether it's in the incarnation of a single 30-hour course or topics to be included in existing courses, would be, you know, defining the broker sales agent relationship, support and training areas of expertise, of course, geographic and subject matter competency. We've talked in this group about what's required in your written policies and procedures. It's essentially, the concept is something that would allow a sales agent to know what they should expect entering their first relationship with a broker. What do I get to expect from my broker? And vice versa, you know, equally important for a potential real estate broker to know what their responsibilities are to their sales agents as they take them on. So in a lot of ways, the concept of this course speaks really directly to a lot of the conversation here. And the notion would be too, that this would be a little different than some of our other qualifying courses, in that it would be more hands-on and there would be a significant number of case studies, interactions. I think, you know, Soccer was talking about the contract scenarios that you had to do in training with your first broker, with kind of that perspective in mind. So that's kind of an overview. You know, we talk in the initial, just kind of really rough draft of an outline. We'll also address teams and understanding teams, which I heard you all talk about in this meeting today as well. What are the designated supervisors? What are their responsibilities, and what is their authority? And this is coming from a perspective of both what the sales agent should know and what the broker should know. So again, in terms of ESAC, you know, they kind of ended up, well, there's going to be a working group, and that working group will be specifically dedicated to the considerations of whether we should lean more toward a single course or more toward integrating it into existing courses. And what else?
This is all really early, I would say, that we're very preliminary on this.
Thank you.
But you can expect to, you know, depending on where this goes, should it go, that this group would have the opportunity to make some recommendations. See, you know, we talked about that ESAC BRWG crossover. I think this is a spot for it. So just wanted to kind of put that on your radars. I know you're all very passionate about this topic.
Thank you. And just so for everybody's education, because I mentioned it earlier, I went ahead and pulled it up. The coursework that has been put out by the Texas Realtors that is specific to broker managers, it's a subscription package that a broker manager can purchase. It starts with an introduction to risk reduction. Then it goes to Legal 1 and Legal 2. Differentiating your brokerage in a commodity market, understanding agency, realtor professionalism, raising the bar, broker responsibility course, media training, succession planning, an industry update, and legislative issues. So those are the courses that are being offered under that subscription package by Texas Realtors. So they are also working on this same front of trying to provide some more broker-specific education. Any questions or any thoughts on that? Seeing none, we will move to our final
I think
agenda
Ty,
item.
did Ty have his
sorry.
hand up?
Well, and so does Bill. Bill has his hand
Oh,
up. Go
no,
ahead,
it's Bill, sorry.
And again, I don't know where we're going on this, but I think in an earlier meeting, maybe last year or something, we did discuss, or we threw out some ideas of how do we get the message out. I think maybe that's the issue that I'm sort of struggling with is it's not what the content is, it's how do we get the message out to people, and how do we get people to sort of read and understand it. And I think that maybe sort of following up on what Chance is talking about, maybe co-opting with Texas Realtors, maybe having TAR, Trek as a partner with maybe also a third, maybe some outside brokerage companies, some larger agents, some smaller, to create basically an outside, I don't know if it's a task force, I don't know what you would call it, but it's some kind of a concerted organization that's task would be to basically help promote education to the general brokerage community, and that they would have sort of some guidelines to do that, or some common goals on how to do that. And I think it sounds like TAR or Texas Realtors is trying to sort of establish a baseline for that. And I think that to the extent that the Trek can sort of latch on to those coattails and maybe sort of help promote it in a nice way through education and through encouragement, I think that would be a solution to a goal of educating people better without making it a requirement. And again, it's just that maybe it sounds like it's real early on, but maybe that's something to think about in a more tangential way that would be more substantial in doing something down the road.
Thank you, sir. All right. So that will move us to our final agenda item, which is discussion and possible action regarding future agenda items and meeting dates. Currently, our next scheduled meeting is April 13th. So mark your calendars. You should already have it on there because we planned it last year, but April 13th. Hopefully we can do that meeting in person, but we'll play that by ear because we had big plans to make this one in person and that didn't quite work out. So mark your calendars, April 13th, same bat time, same bat channel. Anything that we need to discuss prior to adjournment? Anything that we want to talk about in the next go round? We need to prep for now. All right, seeing none. This meeting is adjourned. Thank you for your time. We appreciate you. Thank you again to Commissioner Lerner, and Mr. Warren for bringing all of the good content today. We appreciate you.
Great job.
Y'all have a great day.
Thanks.
Thank you, guys.
Thanks,
Take care.
everybody.
Thank you.
Thank y'all.
Thank you.
Thank you.
Thank you.